Good evening. Welcome to this meeting of the Montgomery County State Delegation. Today is November 27th, 2023, and it is our first set of local bill hearings where we are taking up local and bi-county bills that are pieces of state legislation that have specific focus and impact on Montgomery County. And tonight we're going to be hearing 11 bills and a total of 47 witnesses that are assigned to two of our local House committees, Economic Development Committee and Education, Elections, and Housing Committee. And very shortly, I'll be turning things over to the chairs of each of those committees to take us through the proceedings for each of these bills. But first, I just wanted to give a few logistical remarks and then turn things over to our Senate Chair, Senator Kramer, for his opening remarks. Just as a reminder to everyone, please keep yourself muted until you're recognized by the chair to speak. We will be proceeding through the bills in numerical order, starting first with the Economic Development Committee and then the Education, Elections, and Housing Committee. Our sponsors don't have time limits, but for our other witnesses, if you are with an organization, you have 3 minutes. If you are an individual, you have 2 minutes, and there will be a small timer up in the, I believe, the upper right-hand corner of the screen where you can keep track of how much time you have remaining. We will take questions at the end of each panel. So colleagues, if anyone in the delegation has questions, please use the virtual raise hand function to be recognized by the chair to ask questions. Again, we'll do that at the end of each panel. And I think with that, Senator Kramer, do you have any opening remarks?
Thank you, Madam Chair. Just want to wish everyone a good evening. And this is democracy in action, and look forward to the evening and having the public have an opportunity to show up and speak out on their interests and these bills that are before the delegation. So with that, thank you, Madam Chair.
Thank you, Chair Kramer. Okay, so we're going to get started with the Economic Development Committee, and Chair Lily Chi will be presiding over these bills, and I will turn it over to her to call up the first bill.
Thank you, Madam Chair and Senator Kramer. Welcome, everyone. It's that time of the year again. Can you believe that? I'm Delegate Lily Chi, and I chair the Montgomery County House Delegation's Economic Development Committee. Tonight, we have 6 local bills. We are going to start with MC 924. We're going to start with a couple of alcohol bills. As usual, every year we get a couple of these. We'll get them out of the way. So we'll start with MC 924. Montgomery County Alcoholic Beverages, Class B, beer, wine, and liquor 3 license off-premises consumption. Are we going to go with Kathy Durbin or anyone else? Thank you.
Want to start with me? I'm Melanie Winger, for the record, Director of Intergovernmental Relations for the county, and I can speak to this bill, but I have Kathy and Amy with me. So if it gets too difficult, I'm turning it over to them. But this is a bill that was requested by Montgomery County government. So thank you for sponsoring this for us. And by way of background, it relates to a piece of legislation that passed kind of during the pandemic in 2021, a statewide bill that allowed licensed restaurants and hotels the authority to sell sealed containers of alcohol to customers for off-premise consumption. If you recall, there was a lot of carryout was going on. Some of these places, needed the additional economic assistance. So it was a piece of statewide legislation that passed, but it sunsetted on June 30 of this year. So what we're requesting is to authorize licensed restaurants and hotels in Montgomery County to have the same type of authority on a slightly more limited basis. This would only be for manufactured sealed wine and beer, and it would not allow, as the 2021 piece of legislation did, the ability for like home delivery, which that was allowed under that piece of legislation if it was a restaurant employee that did the delivery. So it's fairly straightforward. Again, just kind of reinstating an authority that our restaurants and hotels had before the sunset of this piece of legislation on a slightly more limited basis. And obviously, since we requested the bill, the county did, the county supports the bill.
Thank you. Does Amy or Kathy have anything to add? Okay. Are there any questions? Oh, yes. I was thinking Delegate Kaiser might have a question. Thank you. Delegate Kaiser.
Usually on these issues. Thank you so much, Madam Chair. Melanie, so good to see you. Just quickly, this is not just extending the sunset, it's eliminating it. Is that correct?
The sunset has already occurred, and that the
Oh.
sunset is on the statewide piece of legislation. So at one point across the state, this was allowed. But that piece of legislation, it was HB 12 of 2021, sunsetted on June 30 for everyone, depending on how your local liquor laws work. But it ended on June 30, the authority for our licensed restaurants and hotels to have the authority to do this. So this would, of sorts, in a more limited way, reinstate the ability just for beer and wine, and it would not be a delivery system.
Any other questions? Okay.
I would just add, this is Kathy from ABS. I would just add that it's with food sales only.
Right. They have to buy food in order to be able to buy off-premise consumption alcohol. Okay.
Yes.
Delegate Linda Foley.
Thank you, Madam Chair. My question, Melanie or Kathy, is, well, Kathy answered my first question, was that they have to buy food. And I assume that that's food for carry out, or is it food in the restaurant? And then they can, I'm just trying to understand what the parameters of so like if I order in a restaurant, can I then buy a bottle of wine to take home? Or
It's to take home, yes.
okay. And then, but if I order carry out, I can also order a bottle of wine. Is that right?
Correct.
Okay. And then my other question is, can it be opened and consumed either on the premises or off the premises? Because there were some loosening of regulations around that. No. So it has to remain sealed.
Correct. At this point, that would be open container.
Okay. Thank you.
Other questions? Thank you very much. We'll move on to the next bill, which is MC 1724, about Class D beer and wine license. This bill is co-sponsored by Senator Craig Zucker and the Delegate Pam Queen. That applies to District 14. So I see Senator Zucker is here. Would you like to go?
Sure. Thank you very much, Madam Chair. For the record, Senator Craig Zucker, along with my fantastic teammates, Delegate Ann Kaiser, Delegate Bernice Merico North, as well as Delegate Pam Queen. We're also here in support of our other teammates, and that's the local farm breweries. District 14 in Montgomery County is fortunate to have a real concentration of farm breweries who are doing great things, amazing things, and you'll hear from some of them tonight. We have Lone Oak, we have Brookville Beer Farm, Wardaka, and Elder Pine. You'll hear from Wardaka and Brookville Beer Farm soon. Colleagues, this legislation might look familiar to you because it is. This legislation passed this delegation unanimously a couple of years ago. And what this legislation does is it provides an opportunity for the farm breweries to continue to be successful by partnering, and it's a local delegation bill only, but it allows it to collaborate with local wineries in Montgomery County to help out both the wine industry and the local farm brewing areas. If you might remember, a couple of years ago, the Maryland General Assembly passed a promotion fund to be able to target into other states and Maryland, but particularly focus on other states to attract people to drink wine and beer in other states that come to Maryland. And it'd be great if they can utilize our farm breweries as one-stop shop. Some of the challenges that the farm breweries have had that my colleagues have heard from the District 14 team is often people are bringing in coffee cups into farm breweries with wine that they're bringing off premise into the breweries. It makes it very difficult for the breweries to tackle this issue. But in reality, they're just we're leaving money on the table when people are coming in from other states and other areas into Montgomery County and not being able to when they're buying beer at the wineries, or they want to buy wine at the breweries, we're leaving money on the table that Virginia is only benefiting in these other states. So With that, we urge a favorable report on this, and I would be happy to turn it over to my District 14 colleagues if they have anything to add. I also, before I do that, I wanted to thank Kathy Durbin and Amy and the Montgomery County government for their great support and leadership on this legislation as well.
Thank you. Do any of the delegates from District 15 have anything to add? Okay, great. You have done a thorough job, Senator. I'm going to turn it over to supporting witness Jessica Snyder from Where DACA Brewing. Is Jessica here? Okay. Is Jessica Snyder?
Yes, I'm here. Can you hear me?
Great. Yes, you have 3 minutes.
Okay, thank you. Good evening, everyone. I'm Jessica Snyder. I'm one of the owners and general manager of Wardaka Brewing Company, a farm brewery located on our third generation family farm in Laytonsville. Montgomery County has spent quite a bit of time and resources to studying improving agritourism in county and specifically in the Ag Reserve. One of the top discussion points is always the comparison of destination farm breweries and wineries in Montgomery County to the same types of businesses in Loudoun County. Both Virginia and Pennsylvania allow farm breweries and wineries to sell each other's products. Being able to cross-promote and sell other state-produced, value-added agricultural products is the hallmark of a customer experience. And Maryland is behind on our Virginia neighbors in competing for customers who want and are willing to travel for that experience. This bill is a viable option to improve agritourism in county through the cross-promotion of Maryland-made beer and wine at sales through farm breweries and wineries. I would love to be able to sell Maryland-made wine at our farm brewery. I think it would enhance the customer experience and provide an opportunity for Maryland makers to expand their customer base, which will increase sales for the makers and farmers, ultimately benefiting businesses and farms in the Ag Reserve. A farm brewery does offer a unique customer experience, but I have to admit that there are other breweries in county that already have the Class D license, and they do have an advantage by being able to serve wine. Baby Cat, for example, which is a brewery in Kensington, and Saints Row, which is a brewery in Gaithersburg, opened with their Class D licenses because they recognized how important it was to their guest experience to be able to offer an array of options. It would be nice for farm breweries to have this same ability while staying laser focused on supporting and promoting the products from Montgomery County's farm breweries and wineries. Additionally, I have had some casual conversations and want to address some concerns that have come up that I've heard from retailers. There are 144 Class D Montgomery County holders in Montgomery County right now, and there are 5 active farm breweries. Even if the number of farm breweries were to triple, this would still account for only a 10% increase in Class D license holders, which I don't think is hardly going to move the needle in terms of competition. I also understand there is some concern about the current language in the bill, which is written to allow off-premise sales. I actually agree and think this is a valid concern and would like to say that I think the bill should be amended for on-premise consumption only. On-premise allows us to support Maryland agriculture and Maryland wineries and breweries. It enhances our customer experiences with adding the on-site option for wine. I do not need to sell any Maryland wine to go. I am very happy to send all of my customers to visit our local retails for all of those sales. Please consider supporting this bill with amended language for on-premise consumption only. And thank you always to Senator Zucker and Senator Queen and Kathy Durbin for their continued unwavering support. And I'm happy to answer any questions. Thank you.
Thank you. You're right on time. Thank you. The next witness is Phil Muth. I hope you pronounced your name correctly, from Brookville Beer Farm. You also have 3 minutes. Mr.
Great, thank you very much.
Oh.
Good evening, members of Montgomery County delegation, and thank you to our sponsors, Craig Zucker, Senator Zucker, Delegate Queen, and Kathy Durbin, of course. My name is Phil Muth, and I'm the owner of Brookville Beer Farm, a Class 8 farm brewery located in Montgomery County for the last 7 years. I'm here this evening to express my strong support for House Delegation Bill MC 1724, which would allow Class 8 farm breweries to offer Maryland wine for on-premise tasting and consumption. As a small business owner and member of the agricultural community, I believe this bill is a reasonable modification that would benefit both consumers, our farm breweries, and our wineries. Offering Montgomery County wine for on-premise tasting and consumption at a Class 8 farm brewery gives consumers a more diverse and inclusive alcohol, gluten-free option. Additionally, some would say a lighter, less filling option. Maryland is home to a thriving wine industry with over 100 wineries producing a large variety of award-winning wines. Offering Maryland wine at Montgomery County breweries would allow consumers to sample these wines and discover new favorites. Farm breweries are an important part of the agricultural community in Montgomery County. They create jobs in our community. They provide a market for Montgomery County grown ingredients that are processed into alcohol products. MC 1724 would help support farm breweries by giving them more opportunities to sell Maryland wine for on-premise tasting and consumption. I urge the members of the Montgomery County delegation to pass 1724. This bill is a reasonable modification that would benefit consumers, farm breweries, and Maryland wineries. Thank you for your time and consideration.
Thank you, Mr. Muth. Just to clarify, you're also supporting the amendment, which is to make it for on-premise consumption only, right?
I do. I think that is reasonable. Yes.
Okay.
Madam Chair.
Yeah.
The District 14.
Yes, Senator.
The District 14 team supports the amendment too.
Great. Thank you. That makes our work session easier and shorter. Thank you. All right. That's all the witnesses for these two alcohol bills. Now we're going to move on to the next group of bills related to the Park and Planning Commission. I would, at the request of the bill sponsor, Delegate Leslie Lopez, I would like to ask her to make some opening remarks about the set of bills that she's sponsoring. And then she will turn it over to an expert from the team, both the work group and also the planning department to speak specifically about each of these bills. Delegate Lopez, please.
Thank you, Chair Chi, and thank you to all the esteemed members of Montgomery County delegation. For the record, my name is Delegate Leslie Lopez, and I am here to present three bills for you tonight: MC 20-24, MCPG 110-24, and MCPG 111-24. And as Chair Chi mentioned, these are the three state bills resulting from the historic and unprecedented work of the Development Review Process Work Group. This work group consisted of representatives from the County Executive's Office, the Planning Department, County Council, executive agencies, community representatives, developers, and the utilities. And before I go into a few broad strokes, I want to thank our county executive, Mark Elrich, and the then planning board chair, Jeff Zients, for coming together to support this effort. And Chair Artie Harris, who's here today, for his continuation of that support. And I'm also thankful to have had the confidence of this delegation when the work group idea was presented last session. I also want to commend everyone who provided public testimony at our 3 open listening tour sessions, and a very extra special thank you to the members of this work group, our third-party mediator, Steve Brigham, Senator Ben Kramer, for committing 5 months to tackling some of the most stubborn and thorny issues that folks in this work group encounter. These were not easy issues, and this was certainly not an easy timeline. And this was not always an easy environment, but nonetheless, people on this work group persisted, and they did the work that the public requires of us as public servants, which is to be responsive, collaborative, and transparent. And the result of their commitment and the persistence of this group is a report with 22 suggested changes that received consensus support. And so I want to repeat that. We came up with 22 consensus policy changes, 19 of which are up to the county council to take action. And you'll hear about the 3 state changes tonight. So first off, MC 2024, the change proposed in this bill is a very simple one. it matches the State Highway Administration review time with the Montgomery County Department of Transportation review time, which is to say 30 days. This is not a deadline for approval, but rather for comment from the administration, as the technical amendments that have been requested make clear. Secondly, MCPG 110-24. The bill's intent is to explore the use of digital signatures on plats and allow for archiving of digital plats. It proposes a change to the real property article to change state law by allowing the archivist to accept digital plats. This change is intended to be another time-saving measure that will streamline the development process. And lastly, MCPG 111-24 works to eliminate up to 3 weeks in the plat approval process by allowing the planning board to conditionally approve plats while the plat is still circulating for signatures and other administrative requirements. There is one amendment being requested that will eliminate the provision related to single signature in the purpose paragraph and is in the body of the bill. Again, each of these bills received full support by the work group, and I am excited to have Deputy Planning Director Robert Cronenberg, who served on the work group, go into further detail about these proposals. And just to close things up, I want to be blunt that when we set out on this journey, there were varied expectations, and admittedly, I don't think I fully grasped how unprecedented this effort was. It's likely the first time in 100 years that this type of state and county effort has been undertaken. And to be very blunt, I think some people had no expectations of this work group that would lead to anything, let alone 22 things. Individually, these suggestions will probably seem very modest, but significant. And collectively, they represent a renewed opportunity for good faith collaboration and commitment to the public. And so I thank you again for everyone's participation, robust participation, and I thank the delegation here for your consideration. And I'll be happy when the time comes after Mr. Cronenberg goes into detail about the bills a little bit more specifically. I'm happy to answer your easy questions and let Robert take all the hard ones.
Thank you, Delegate Lopez, for chairing the work group and for introducing the bills and these remarks. So next, MC 2024 is about State Highway Project approval. Mr. Cronenberg, do you have any other remarks in addition to what Delegate Lopez has said? Would you like to go through each of them?
If you don't mind, Delegate G,
Not at all.
Go through all three of them at the same time, but I will definitely call out the bill number before I go into that piece of testimony, if that's okay.
Could you hold on one second? I think Delegate Kaiser might have a question.
Sure.
I did. Thank you, Madam Chair. My question was for Delegate Lopez. I don't know if this counts as the easy question or the hard question. I was just curious, and I may have missed it at the beginning while I was looking up the documents, in terms of the description of the problem. How long is it currently taking, and that this 30 days will be the fix for?
So it's 45 days, right? But the problem is that it's not necessarily concurrent. And so on the conservative end, it will take off 2 weeks of the process there. But collectively, if we pass these 3 state bills together, as they have been hopefully corrected with technical amendments, it will take about 6 weeks off the development review process. And again, that's a conservative estimate based on the SHA alignment when things start.
Thank you.
Thank you. All right, Mr. Cronenberg, please start with MC 2024.
Thank you so much, and good evening, and thank you to Delegate Lopez. I'm Robert Cronenberg, Deputy Director of Montgomery Planning, and thank you for this opportunity to testify today. We worked closely under the leadership of Delegate Lopez, who chaired the Development Review Process Work Group this summer. The following 3 bills directly came out of the 22 consensus recommendations from the work group, and we want to thank Delegate Lopez in support of the legislation that's being introduced and that is in support of the work group recommendations. As the sponsor mentioned, there are a few amendments that are coming through, and I'm going to go into a little bit more detail now. So for MC 20-24, the Maryland National Capital Park and Planning Commission supports MC 20-24 as amended. The amendments include language consistent with the Development Review Process Work Group's recommendation to require SHA to complete its review and provide comments within 30 days of any public or private development project requiring access to the state highway. And to Delegate Kaiser's question, there is no timeline right now. The 45 days is historically what is the timeline that SHA provides comments. So this would actually provide a timeline that is consistent with MCDOT and their review. And as mentioned, I was a member of the work group, and the intent of this recommendation was to create language in the state law limiting SHA's review time on development applications to 30 days. This would align the SHA review time with county DOT and other agency review times, thereby ensuring the applicant has all transportation comments at the same time to address them efficiently. We appreciate the sponsor making these revisions to align with the work group recommendations, which would include changing highway construction projects to public or private development projects requiring access to state highway, and to replacing render a decision of a proposed highway construction project with provide comments for an application for a development project. For these reasons, the Commission supports the bill as amended. And Delegate Chief, if you'd like me to go into the other two bills, I'm happy to do so.
Yeah, please take a pause because we do have other witnesses on these bills. And I also see Chair Mark Corman's hand is up. Delegate Corman, please.
Thank you, Madam Chair. My question is, I see State Highway submitted a letter on this. I don't know if this is for Delegate Lopez or Mr. Cronenberg, but do you have a response to their letter? They seem to be aware of the amendments, but still seem to have concerns. Could you just address those?
Sure. So I brought this up, several months ago when it was kind of a bud of an idea. And so I haven't had the opportunity to chat with them after the amendments have come through. I think it's just a matter of discussing it with them and kind of clarifying some things. There was, as you can imagine, a little bit of a disconnect between the way things are drafted in county legislative language and the way DLS drafts them. And so I think we're just in the process of ironing these things out that are technical. So I'm assuming that the technical amendments will be able to address what their concerns are.
Thank you. Any other questions? Okay. We have a witness for this bill, Seth Grimes, who represents WABA, the Washington Area Bicyclist Association.
Thank you, Chair Chi, and Chairs Kramer and Polakovich-Carr, and members of the delegation. The Washington Area Bicyclist Association is an advocacy organization with over 1,200 Maryland members, and we support MC 2024 with amendments. This bill would require a state highway administration decision on proposed highway construction projects within 30 days and so on. I will note that Maryland Transportation Article 8101 I-1 defines highway to include walking and bicycle paths. This bill addresses an actual need. I became aware of an onerous and cumbersome application approval process myself earlier this year in conversations with MCDOT staff. I was told that SHA construction project review routinely takes far longer than is reasonable and justified given the scope and complexity of project applications. I was told further by MCDOT staff that after the organization responds to the SHA's review points, second round review may be assigned to a staffer other than the one who conducted the first round review, and that person may open new issues. Therefore, we suggest amending MC 2024 to disallow identification of new issues in second round review. Delegate Lopez, I recognize that this is the work of a working group and that you may not be accommodating given the process so far of amendments, yet I will mention that one amendment request and some others. Regarding MDOT, Maryland Department of Transportation, SHA strictures applied to local projects, we also suggest reform to allow a locality to apply directly to the federal government for experimental roadway treatments with flashing yellow arrows as an example, and elimination of the restrictive Maryland supplement to Federal Highway Administration Manual on Uniform Traffic Control Devices. Finally, a holistic process for review of stormwater management for bicycle, pedestrian, and transit projects in built environments should be mandated, recognizing that stormwater handling may be addressed area-wide. These reforms, which I recognize once again go well beyond the mandate of the working group and recommendations, would, however, facilitate design and construction of projects that would boost multimodal transportation options and road safety. WABA therefore recommends you advance MC 2024 with amendments, although we recognize these amendments would greatly expand the scope of the bill before you. Thank you very much for this opportunity to comment.
Thank you. Okay, any questions from our members on MC 2024? Okay, seeing none, then we'll move on to PGMC 110-24. It's about Clerk of Court subdivision plat recordation. You have heard from Delegate Lopez, so I'm now going to turn to Mr. Robert Cronenberg. You have 3 minutes.
Thank you again, and good evening. Robert Cronenberg, Deputy Director with Montgomery Planning, and PGMC 110-24 will support streamlining the development review process by leveraging digital access and tools. Currently, state law requires plats to be on Mylars, preserved in a book by the state archivist. This requires circulation of the actual Mylar drawings to various parties and government agencies for signature, which can take several weeks or more. As background, a record plat is a plan drawing prepared by a licensed land surveyor that depicts an approved subdivision or assemblage of land and associated easements or restrictions. Plats must be recorded before any new lots can be sold or building permits issued. By allowing digital signatures and archiving with the digital signatures, this will allow the process to move forward efficiently as opposed to physically transferring a Mylar copy through multiple agencies and locations. Therefore, the Commission supports PGMC 110-24 as amended. Thank you.
Thank you. Sometimes when you hear things like that, you wonder, why haven't we done it already? Right? Which is something we tried to do back when I was working in the county about digitization of forms, but it's the same concept. Any questions? Okay. All right, then let's move on to PGMC 111-24, subdivision plat conditions. Again, I will call upon Mr. Robert Cronenberg. You have 3 minutes.
Thank you again, Robert Cronenberg, for the record, with Montgomery Planning. So PGMC 111-24 would allow Montgomery County Planning Board to tentatively approve a subdivision plat subject to specified conditions. As I stated before in the intro, I was a member of the work group that proposed this legislative change in an effort to make the development review process more efficient. So once a subdivision plat is submitted to the Planning Department, it is circulated to the Montgomery County Department of Permitting Services, DPS, and others for their review. With each review cycle, the Planning Department consolidates comments and returns them to the applicant for corrections. The review cycle will be repeated until all agencies deem the plat acceptable and sign it. And then it must go to the Planning Board in public session. There's often several weeks spent obtaining signatures before the plat can go to the Planning Board. This bill will allow an applicant to receive Planning Board approval of a plat in a public session while the plat is still circulating for signatures and other administrative tasks. Once the plat is conditionally approved by the Planning Board, it would not need to go back to them for another public session so long as all of the conditions are met. During the summer's development review process work group, members voted in support of adding specific language in state law that allows for conditional Planning Board approval of plats. This will help subdivision plats move more quickly through the approval process with an expected savings of at least 3 weeks in the development review process. For these reasons, the Commission requests a favorable vote in support of PGMC 111-24. Thank you so much.
Thank you. Any questions? Seeing none, thank you very much. Okay, we are down to the last one for the Economic Development Committee, which is PGMC 112-24. It's the Maryland National Capital Park and Planning Commission People's Council for Land Use. The sponsor is Senator Kramer, Ben Kramer. Senator Kramer.
Thank you, Madam Chair, and good evening, colleagues. Ben Kramer to introduce PGMC 112-24. Colleagues, the Montgomery County Code provides for a People's Council to help residents understand the very complex land use process in Montgomery County. And if I may, I'll read just the first couple of sentences of the statute and county code that created this position and the reason for it. Informed public actions on land use matters require a full exploration of often complex factual and legal issues. An independent People's Council can protect the public interest and promote a full and fair presentation of relevant issues in administrative proceedings in order to achieve balanced records upon which sound land use decisions can be made. In addition, a People's Council who provides technical assistance to citizens and citizen organizations will encourage effective participation in and increase public understanding of and confidence in the county land use process. Colleagues, I would proffer to you that that is a significant statement in the statute the county has creating the position of the People's Council. Here's the problem. Our county council has not funded the People's Council in 13 years. The county executive, both current and predecessor to the current county executive, have included in their budgets every year the People's Council position, and the county council has not funded the position. So all the goodwill that perhaps could have been created over the past 13 years by fulfilling the requirements and the dream of what this position entailed have gone by the wayside. Now, this came very much to my attention during the work group that Delegate Lopez was referring to. And there was, in fact, a good deal of discussion about the fact that the county and the county's residents have not had the benefit of this People's Council and all the good that People's Council could be doing. I will note that Park and Planning's opposition, and I'm not quite sure what we're gonna hear, because I see that signed up. We have the chair and one other representative of Park and Planning signed up in support of the bill with an amendment, which I am not familiar with at this point. And then someone else from Park and Planning, Mr. Cronenberg, who we've heard from this evening, is signed up in opposition. So I'm not quite sure where Park and Planning will be coming from until we hear Park and Planning. But I note that they, in their letter of opposition, Park and Planning opines that although the work group considered and thoroughly discussed the People's Council role, this recommendation did not receive enough support in the work group to make the list of recommendations. Colleagues, let me share with you what the requirement for making and qualifying a recommendation was. it required a 2/3 supermajority of the work group for a recommendation to make it into the final work group report. Here's the vote on the People's Council bill as recorded in Park and Planning's own notes on their website. There were 10 votes in favor of the People's Council. There were 5 votes in opposition. The notes on the record reflect that the 5 opposition votes were the developers on the work group, oh yes, and the Park and Planning representatives on the work group. Those were the 5 opposition votes that Park and Planning now, I would proffer, being a little disingenuous in their opposition, says, well, it didn't have the support of the work group to get there. Well, the 10 votes that weren't part of the developers or Park and Planning were all in favor of the People's Council. And I will also proffer you, I'll share with you first that the notes from that meeting reflect the following. There was discussion with particular focus towards groups who have been historically underrepresented in land use processes consistent with the Racial Equity and Social Justice Act. That's the bill that our Park and Planning representatives voted against, along with the developer representatives. Colleagues, the bill before you simply offers the following. The county executive shall appoint a People's Council for land use planning. And the intent is to represent the public interest of county residents in proceedings related to land use planning and ensure fairness to populations that have been traditionally underrepresented in the county land use planning process, and to ensure that a complete public record is established for proceedings related to land use planning. Now, if the bill continues, that making it very clear, colleagues, very clear, that the People's Council may not represent a private individual or an interest group in any proceeding. And I know I have read in one of the opposition letters that somehow this person, this People's Council, is going to be representing rich people in the county for free at the taxpayer expense. To the contrary, the bill stipulates and specifies the People's Council is not there to represent any individual, but they are there to ensure fairness in the process and that we have social equity in the process, which has been lost over the past 13 years that our county council has refused to fill this position. Now, the bill continues that the county executive makes the appointment. Park and Planning Commission will fund the position, and the county council will include in its annual, the county council shall approve funding for the People's Council as provided in the commission's budget. Now, once again, Park and Planning in their letter of opposition opines that this is a county prerogative, and there are concerns expressed as to, well, the state legislature does not have the authority to do this. Colleagues, sent to every single one of you today, whether you've had a chance, doesn't matter if you haven't had a chance to see it yet, is a letter of advice dated November 21, 23, from Mr. Jeremy McCoy. I know you all are familiar with him, in the Attorney General's office. In that letter, Mr. McCoy makes it absolutely unequivocally clear that the Maryland General Assembly absolutely has the authority to enact the bill as it is before you. And in sum, he says, in my view, the General Assembly has the authority to enact all three requirements under the proposal. It is well established that the commission is a state instrumentality and not a part of county government. Although the General Assembly's control over home rule counties has been limited to some degree by the state constitution, no constitutional provision prohibits the General Assembly from imposing a financial burden on a county. And then he continues on to quote the law, prior findings from other attorneys general, and makes it very clear that the bill before you is constitutional. And in fact, the proper authority for ensuring this is done is in fact in your hands and in the hands of our colleagues in the General Assembly. I would ask that we ensure going forward, colleagues, that this position be filled. It adds no additional layers to the development process. The People's Council, if choosing to do so and testify at a public hearing, will be at the same public hearing anybody else would be attending. There are no additional layers of development or adding anything cumbersome to the process. What it does is restore faith and hope in our residents that they are, in fact, being heard, that they are part of the process as envisioned in the original county code, which states that is why it is so important to have this position. Our neighbors in Prince George's County have this position. Baltimore County, Howard County, they have this position. Montgomery County does not. We owe it to our residents, and we owe it to transparency, good government, to ensure that this position is filled going forward. And this bill is our opportunity to do that. Thank you very much, colleagues.
Thank you, Senator. I see this, our staffer, Montgomery County Delegation Staffer, Ralph has a question.
Apologies, not a question. I do want to correct the record because there was an error in the sheet that you guys were looking at. All of Park and Planning is here in opposition to the bill. So I just want to correct that mistake that I made and make sure that that is on the record. I don't want to misrepresent their positions for anyone.
Thank you for that, Ralph. It certainly clarifies and makes better sense out of what's on the witness list. So thank you for that.
Yeah, the version I got is the correct one. Thank you. Thank you, Senator. And let me call upon the witnesses. We have quite a few supporting and quite a few opposing. Let me see. First, I don't think I see any hands from members for the senator at this point. I'm going to call upon Elizabeth Joyce, who represents the Montgomery County Civic Federation in support of this bill. You have 3 minutes.
Good evening, Delegate Chi and all delegate members. Delegation members. I'm Elizabeth Joyce, speaking for the Montgomery County Civic Federation. Thank you for the opportunity to voice our support for Bill PG-MC 11224 to require the appointment of a People's Council for Montgomery County to represent the public interest in land use planning. In the past, the OPC has promoted full and fair administrative proceedings, sound land use decisions, and crucial information for residents on complex land use policies that directly affect their lives, but they often have no access to information about. Although the county OPC operated for only 9 years, its two-person staff accomplished a great deal. From 2002 to 7, the OPC participated in 267 land use proceedings and provided more than 18,000 instances of technical assistance, as well as 47 mediation sessions. The highest budget level was $250,000 per year, a mere 0.0004% of the county's current budget. The First People's Council was known for de-escalating conflicts, solving problems, and preventing expensive delays and legal challenges that cost a lot of money. A 2008 report from the Montgomery County Office of Legislative Oversight, OLO, cited praise for the OPC from residents, government officials, and land use attorneys, detailed in my written testimony. Contrary to critics' claims, the OPC did not favor residents at the expense of other parties or serve to stop projects. The OLO study cited a 2007 report showing that the OPC, quote, most often appeared in support of an application or remained neutral. Despite this clear evidence of the OPC's public service, the Montgomery County Council fiercely opposes the OPC. They rejected the bill at this morning's state legislation session, where one council member falsely stated that the bill would force the county to fund the OPC. Yet Title IV-E clearly states, quote, the commission, that is the Maryland National Capital Park and Planning Commission, shall include adequate funding for the OPC in its annual operating budget proposal, unquote. Focusing only on their fear of losing power, the council vice president called this bill dangerous and extremely adversarial. So much for the public interest. I respectfully urge the delegation to advance this reasonable and needed legislation. Only the General Assembly can give Montgomery County residents this key service that residents of so many other Maryland jurisdictions enjoy. Thank you.
Thank you. Next, we have Cheryl Gannon as individual.
Good evening. My name is Cheryl Gannon.
You have 2 minutes. Thank you.
The planning for both Montgomery and PG counties falls under a state by county agency, but a disparity exists in that the commission provides funding and a statutory framework to PG for a People's Council, but not Montgomery County. The agreement between the commission and PG states that the funding is, quote, in furtherance of the commission's obligations and responsibility under the state land use article. This acknowledged responsibility of the commission to provide a People's Council must apply to Montgomery as well. Numerous misstatements about the existing county statute and the state bill have been made in public meetings of the council and the planning board that have clouded the discussion. To summarize a few from my written testimony, the council said today that the bill amounts to an unfunded mandate, although the bill is very clear that the commission will be providing the funding just as it does for Prince George's County. It's been said that a People's Council duplicates the work of the planning staff and the council. While the council and the planning board weigh competing interests of various parties, the People's Council's sole focus is articulating a position in the public interest. The council and the planning board don't have to agree, they just have to listen. What the planning board and the council are really saying is that they do not want to give space to competing views. They don't want to hear it, and they don't want a People's Council position in the public record. The council and planning staff have repeatedly said it's too difficult or tricky to define public interest. And yet last week, right after planning staff said it was too tricky, the chair of the planning board said, we act in the public interest. So council members and state legislators and the planning board, for example, all act in the public interest. People's Council offices operate in the public interest in 4 counties in the state, covering 2.5 million Maryland residents. But we're asked to believe that only in Montgomery County, it's not possible to define the public interest. Finally, it's said that it will be used by rich people to stop projects, even though the People's Council does not have the ability to stop anything. The decision makers remain the same, the planning board and the council. In summary, if you think about it, it's not credible to think that the council and the planning board are asking you, please stop us before we can agree with the People's Council position. That argument comes from—
Anna, your time is up. Please wrap up.
The council and planning board on behalf of developers. Thank you.
Thank you. Okay, next we have Catherine Katzen. You also have 2 minutes.
Hi, thank you so much for giving me the opportunity to speak tonight in favor of Bill PGMC 112-24. According to current county code, an independent people's council can protect the public interest and promote a full and fair presentation of relevant issues in administrative proceedings in order to achieve balanced records upon which sound land use decisions can be made. In addition, a People's Council who provides technical assistance to citizens and citizen organizations will encourage effective participation in and increase public understanding of and confidence in the county land use process. Those words were adopted into law in 1999 when then Council President Ike Leggett sponsored the bill that initially established the county's OPC. Land use decisions and the rules and regulations that govern them are complex. Decision makers rely on relevant parties to submit information on the official record so that they can make informed decisions. It should not be the case that the only voices on the record are those with the financial resources to hire attorneys and navigate these complex processes. The OPC provides a mechanism for information to be presented on the record so that decision makers can make high quality decisions. Vulnerable populations are some of the greatest beneficiaries of a People's Council. As some of you know, the County Council considered a bill to eliminate the county mandated OPC earlier this year. Thankfully, the bill did not pass. The county's Office of Legislative Oversight prepared a racial equity and social justice impact statement. OLO concluded that eliminating the OPC would widen racial and social inequities in the county. I urge the delegation to support this very important legislation. Thank you.
Thank you. Next, we have Peggy Dennis. You also have 2 minutes.
Thank you, delegation. I'm also speaking in support of Kramer's most excellent bill. Home ownership is the most important way for families to build wealth, regardless of their race, ethnicity, or economic status. For years, families have relied on zoning to assure them of the stability and predictability of the neighborhood they are buying into. The upzoning of Thrive will throw out the baby with the bathwater. Such major changes to neighborhoods will threaten to change the surety of this biggest of all purchases. Having developers buy existing single-family homes and turn them into 2, 3, and 4 dwelling units will change neighborhoods and pit neighbor against neighbor. Legal challenges will multiply, and the need for objective and easy-to-understand information and guidance on our land use processes will be essential. This is especially true for Black, Indigenous, and people of color, who may be the newest and least experienced of homeowners. As the Racial Equity and Social Justice Impact Statement put it so succinctly, offices of People's Council can be uniquely positioned to advocate for the interests of BIPOC and low-income constituents, not typically represented in land use decisions. Other Maryland jurisdictions have established People's Council offices, and these offices have served the broad public interest very professionally. Why should Montgomery County not be similarly served? The bill before you seeks to shield the office of the People's Council from the vagaries of the council, which chose to defund our original OPC. This defunding left all the homeowners of Montgomery County, especially without the funds to hire pricey land use attorneys, at the mercy of a planning and land use system that may well serve the interests of the development industry, but not be in the best interest of the residents. Thank you.
Thank you very much. We have 3 more witnesses who signed up to support. Next, we have Jemison Adcock. You have 2 minutes.
Thank you. I want to thank you all for the opportunity to testify before you. And I also want to thank Senator Kramer for submitting this bill. I want to start by saying that the OPC is very popular. As an officer of the Aspen Hill Civic Association, our board has repeatedly, unanimously supported this and sent letters in support. I will also say that our membership, when I've spoken to members of our Civic Association, every last one of them supports this. They're in favor of this thing. Mainly because it levels the playing field. Ordinary residents need to have someone in their corner to provide technical assistance and information about a very complex process. And land use is certainly complex. People can find themselves on the opposite side of an issue from the county council and the planning board. And so we need to have somebody that is going to act in the best interest of the public. And ordinary residents don't have teams of highly trained, expensive lawyers as developers do. So again, this levels the playing field. And lastly, one of the things that has been thrown out is that this would be good for racial equity and social justice. And I can't imagine any argument that would say contrary. If you have an unbiased, person who's working in the public interest, that is not, benefiting rich folks. It's benefiting average people. And I do also want to say that other counties around the state have this. Why shouldn't Montgomery County? So I urge you all to support this bill. We need to have a People's Council that is funded. The county council has refused to fund the bill or fund the law, and I think that's it flies in the face of the law. And quite frankly, I find that sort of thing a bit cowardly and weaselly. So please support this bill, and I thank you for your time.
Thank you. Next, we have Daniel Major. You also have 2 minutes.
Good evening. My name is Daniel Mayer, and I have lived in downtown Silver Spring since 1978. I would like to testify in support of MCPG 112-24 that will fund the Montgomery County People's Council by the state, as is done in neighboring Prince George's County. I believe a People's Council that is not funded by the Fox, which I see as the council, will be in a better position to guard the chicken house, which I see as land use regulations. For example, a Gazette article describes an incident former Senator Ida Mae Garrett experienced when she was a member of the Montgomery County Council that exemplifies how developers can use their financial resources to persuade our Montgomery County Council members to change zoning legislation. And I quote her. She says, "This always sort of rankled with me. I felt it was not entirely proper." This still goes on today, but via a zoning text amendment, ZTA, process that primarily benefits a particular developer. That developer then later contributes a generous amount of money to the campaign account of the Montgomery County Council member who introduced the ZTA. A People's Council would be in a position to notice that, which is why I believe the Montgomery County Council continues to refuse to fund this needed office, and thus the state needs to step in, as in the case in neighboring Prince George's County, to fund the People's Council without fear of financial retaliation by the Montgomery County Council, which is the case now. Thank you.
Thank you, and I apologize. Your last name is Mayer.
Everybody gets it wrong. Don't worry about it.
Just like mine.
In Holland, Mayer is as common as Smith.
Great, thank you. The final witness in support of this bill is Sue present. Sue, you also have 2 minutes.
Good evening, delegates. My name is Sue Present. I'm here to support Bill PGMC 112-24. A funded operational People's Council is sorely needed in Montgomery County. From my personal experience and observations, I can tell you that our land use rules and regulations range from complex to utterly confounding. Land use attorneys, especially the ones that have made practicing before county land use decision-making bodies their niche, tend to have the upper hand. They're the ones that often represent large developers, industry, and other special interests. By contrast, residents often find themselves at a severe disadvantage at land use hearings, and residents also confront obstacles prior to the hearings. For instance, affected residents, unless represented by counsel, are routinely excluded from important pre-hearing proceedings, and they're generally barred from filing pre-hearing motions too. Barred even to raise material issues of public interest. But with the passage of this bill, In county land use proceedings, the People's Council would represent the public interest of county residents, ensure fairness to populations that have traditionally been underrepresented, and ensure the establishment of complete public records. So to promote equity and fairness in our land use proceedings, I urge you to adopt Senator Kramer's bill. Thank you.
Thank you. Do any members have questions for the supporting panel for the bill sponsor at this point before we turn to the opposing panel? Okay. Right. Seeing none, I'm going to call upon the 4 witnesses that have signed up to oppose. Okay, first, the Bob Enton. Okay, Bob, you have 3 minutes on behalf of the Maryland Building Industry Association.
Thank you very much, Madam Chairman. My name is Robert Enton. I'm an attorney, and I'm here today this evening, representing the Maryland Building Industry Association, which is a statewide trade association of home builders. We are signed up in opposition to the bill, and I spent a fair amount of time. I reviewed the position statement from Parks and Planning. I've looked at the Montgomery County Planning Board history, its background, its members, and listening to the testimony today. The point was made that this is not to have someone that will represent individuals. But I think that's the impression. If you listen to the testimony of the proponent witnesses, that's what they think the effect of this will be. That you're going to now have someone who's going to, a lawyer who will represent the individuals who are going up against developers who are generally, in fact, are represented by counsel. I think that it's not appropriate. There are lawyers in Montgomery County that represent developers, and there are lawyers in Montgomery County who specialize in representing homeowners. There is a process. If you look at the backgrounds, I'm looking at the website of the board members of the planning board. I see 2 African American men. I see 1 woman. When you look at their bios, none of these board members, almost every one of them, has a background of working in the community. I've not heard any testimony from anyone that says that decisions that are made by the board are biased, that they're unfair, that there is, in fact, racial inequity. Montgomery County sits on 363,000 acres of land, and you probably have the most robust planning department in the entire state of Maryland. And the process is laborious. If you've been through it, I've been through it. It's laborious, it's detailed, but I haven't heard any witnesses say that it's unfair. I haven't heard any witnesses say that it's unbiased. The county council, which only represents Montgomery County residents at the local level, has decided that this doesn't need to be funded. We think that it'll add another unnecessary layer of bureaucracy to the development process that you have today. There's probably nothing more important maybe today in Montgomery County and other counties than making sure there's affordable housing. We think that this will not have a positive impact on affordable housing. It'll slow the process up and limit the ability of my client and its members.
Your time is up.
I'll wrap up. To go ahead and develop affordable housing. For all those reasons, and with all due respect to my good friend, Senator Kramer, we are opposed to the bill.
Thank you. Next, we have from Park and Planning, Mr. Robert Cronenberg. You have 3 minutes.
Yeah, so Madam Chair, I'm going to go in front of
Oh, okay. Chair Artie Harris on behalf of MNCPP.
Yeah, well, thank you and good evening. I'm Artie Harris, Montgomery County Planning Board Chair. Thank you for this opportunity to testify on Bill 112-24 on behalf of the Montgomery Planning Board. Earlier this year, the Planning Department participated in an extensive development review process worked with under the guidance of Delegate Lopez. In addition to planning staff, the work group had members from the community, the executive branch, and council representatives. The work group released a report in October that highlighted 22 recommendations to streamline and improve the development review process in the county. In order to acknowledge the time, commitment, and thoughtfulness of the work group, the planning board requests that only legislative action stemming from the 22 consensus recommendations be moved forward. All parties should be given the time to implement these recommendations before additional policies or legislative requirements are approved. In this regard, the planning board is opposed to Bill 112-24. The work group discussed the People's Council, but specifically chose not to make any related recommendations. Additionally, the Office of the People's Council for Land Use Planning in Montgomery County would be a duplication of the efforts of the Planning Department, Planning Board, and County Council. The county already has a position identified to conduct the work with the People's Council. The position is currently unfunded, with the council discussing as recently as fiscal year 24 budget cycle. It's up to the county council, if it desires to do so, to fund and activate this goal. The planning board opposes Bill 112-24.
Thank you, Mr. Harris, Chair Harris. I see a couple of hands. Senator Kramer.
Thank you, Madam Chair. And Mr. Chair Harris, my question for you is the following. Your opposition to the bill seems to be very much rooted in the fact that the work group did not, and I quote, specifically choose to make this recommendation. Chair Harris, would I be correct on the record this evening if I were to say that when the vote for the People's Council position was discussed by the work group, that the conversation very much from the citizen representatives on the task force centered around racial equity and social justice. And when the vote was taken, the final vote was 10 in favor of the People's Council being included, 5 in opposition. And those 5 entirely were comprised of developer representatives and Park and Planning Commission representatives. Is that an accurate statement, sir?
I don't know the record of if you say so, that's what you say. I'm just saying the rules were the rules. So, and I'm going to go on to, and I'll move on. The rules were the rules. And then secondly, I would just say, all of what we do in the Parks and Planning, all of the master plans that are rooted in equity. So that's the vote. That's what the vote was, and that's how the recommendations were provided.
So the recommendation did not receive the 2/3 supermajority vote by virtue of the Park and Planning Commission voting against it. I understand. Thank you, sir. But the rules are the rules, and the legislature is the legislature. Finally, in that regard, Mr. Chair, and you may or may not be familiar with the conversation that the notes of the event reflect, but the commission was asserting the position that this recommendation for the People's Council was outside the scope of the development review process, outside the scope. So in fact, if this bill is before this delegation as a separate piece of legislation, this would be satisfying Park and Planning's position that, well, it shouldn't have been part of the work group discussion in the first place. So now I am saying to you, sir, we have this bill outside of the scope of the work group, as was asserted by Park and Planning's representatives. Hey, this shouldn't even be discussed in this work group. It's outside of the work group. Would that be an accurate assessment that now, in fact, we are outside of the work group, as was stated by the representatives of the Planning Commission?
Mr. Harris, would you like to respond?
Senator, we're opposing bill number 112-24 and 5.
Thank you, Mr. Chair. Good to see you tonight.
Chair Harris, I just want to point out it's kind of hard to hear you. I don't know if it's just me, but you might want to check your audio system for next time. Thank you. And I see Delegate Kaufman's hand has been up. Delegate Kaufman.
Yes, Madam Chair, can you hear me?
Yes.
Thank you. Mr. Chairman, Mr. Chair, I want to offer you my congratulations, or I guess some days condolences, on your new appointment to the chairmanship of the Planning Board. I want to just ask you, because you said that some of your, you said the bill isn't necessary because Senator Kramer's bill is duplicative of what the Planning Board is already doing. So if you could just elaborate as to what's duplicative, what are you already doing? And also, if you could talk about what you are going to do to make the public more aware of this duplication, because it's clear that the proponents don't feel that that this bill is duplicative. So what are you going to do to better alert the public as to the services you provide?
That's a great question. I think we could answer in 5. And Robert, the planning department has a good topic.
I'm sorry, Madam Chair, but I cannot hear Mr. Chairman.
I'm sorry. Can you hear me at all?
Yeah, I can hear you.
Try to speak up and to the microphone as much as possible.
The planning department has a great outreach process for all the plans that we put out there, either the master plans or the project plans, reaching out to the community. That's one piece that we do. We pride ourselves in our outreach program. The second is that once the planning board votes on it and it goes to the council has a great outreach program. The first it goes to the council committee that hears it, and there could be public testimony in the committee stage. And then once it goes from the committee to the general council, the council then has another deliberative process that the council goes through. So I'd say we have a great process where the community can get involved and provide testimony and get issues addressed in that process. That's the process we have on the planning side, the planning board side, and also well with the council, and 2 bites of the apple with the council on the committee side as well as the regular full council.
Thank you.
Okay, I thank you, sir. I would just encourage you to redouble your outreach effort, because it's clear from the proponents they don't feel it's sufficient. Thank you, Madam Chair.
Thank you. Next, we have Delegate Spiegel.
Thank you, Madam Chair. I just had an informational question, and frankly, I'm not sure if this panel or the previous panel or the senator, the sponsor, is the right person to answer the question, but I know it's been mentioned over the course of the discussion and the testimony that there are other jurisdictions around the state that already have these positions in operation. And I just wanted to understand if those other jurisdictions, if they had authorized this position by local legislation, or if there was state legislation that had done so, and if they are funded by state or local dollars, if anybody knows.
If I may, thank you, Delegate Spiegel, for that. I'm not aware of any of the positions that are funded with state dollars. To the best of my knowledge, it's all done locally. In Prince George's County, they do their people's council, and I'm guessing there may be some people ready to correct me, but I believe it's through the county executive's office, and Park and Planning is required by law to reimburse them for the cost of the position. So I am unaware that there are any of the People's Council positions for this intended purpose that are funded by state dollars. And but the reason we are looking to do it the way we are is that we have had county executives, as I mentioned, for 13 years, including the position in their budgets, and the county council has refused to fund the position, so it goes unfilled. Doing it the way this bill stipulates, then we would in fact have the position as was originally intended in county code, and the Park and Planning Commission would be required to fund it, and the county executive would make the appointment.
Thank you. I understand. In terms of just a quick follow-up, in terms of the authorizing legislation for this position, apart from the funding question, in other jurisdictions, has that ever been modeled similar to the legislation before us, or has it always been just that they created their positions through local legislation, if anybody knows?
And again, my understanding is that, typically speaking, as was previously done in Montgomery County, the local jurisdictions valued and appreciated the role of this position and were very willing to ensure the position existed within their jurisdictions. We're a little bit unique here in Montgomery County, that there has been a conflict between branches of government, and I believe we have lost the appropriate transparency, good governance, and service to the people over branch warfare between the executive and legislative branches in the county, and that because of the way Park and Planning simply is established, and we're unique in the country in having the system we do with Park and Planning and with Montgomery and Prince George's, that the delegation, the state has the jurisdiction here, and it's appropriate for the state now to step in and address it.
Thank you.
Thank you.
Thank you. Let me go through the couple more witnesses we have. I still have on my list Mr. Robert Cronenberg of MNC PPC, as well as Deborah Borden. Both of them are from the same organization. Are you still going to testify, Mr. Cronenberg? Okay, please go ahead.
Yes, thank you so much. I'm Robert Cronenberg, Deputy Director of Montgomery Planning, and thank you again for the opportunity to testify today. I was a member of the Development Review Process Work Group, and as directed by the Montgomery County delegation, the work group came to consensus on 22 recommendations to improve the development review process, and expressly rejected several others. I can say that there was significant discussion, disagreement, and ultimate consensus on certain items as part of the intensive 4 to 5 month process. And to reject these findings by introducing legislation that is not consistent with those recommendations is really unfortunate. Members of the work group, myself included, spent many hours during and outside of the workday creating, reviewing, and analyzing data, preparing presentations, and making proposals for the group consideration. We hope that will not be lost in this process. One of those rejected recommendations was the creation of a state-sponsored People's Zoning Council. And I would like to just provide some clarification as to the vote that's been mentioned a couple times. Yes, there were 8 that supported it. 10 that supported it, voted yes, 5 that said no, and 2 that abstained. Those 2 that abstained counted as opposition. So that a little bit of clarification in terms of the vote. The work group did not recommend this in large part because it resides within the purview of the Montgomery County Council to do so. And there is already a position which the county council can consider funding if it deems appropriate. For the reasons stated above, the Montgomery County Planning Department opposes this bill. Thank you.
Thank you. Next, the last witness is Ms. Borden, Deborah Borden. You also have 3 minutes.
Thank you, Madam Chair. I'm Deborah Borden. I'm the General Counsel for the Park and Planning Commission. I'm only here to answer questions directed at Park and Planning, help answer questions. I am certainly familiar with the People's Zoning Council in Prince George's County and how that is set up. So I'm happy to answer any questions you might have. Thank you.
Thank you. Do any members have questions for the opposition panel? Missing any hands. So I'm saving my question for the last. I have a question for the bill's sponsor, Senator Kramer. So since in Montgomery County, the county council has the authority over zoning and land use, would this position, even though it's reported by, it's appointed by the county executive, would this position report to the county council or the executive?
It would not report to either. The fact is, this is an independent position. It is not beholding to any entity, much as we have inspector generals that are not beholding to entities. The People's Council would not report to either. The People's Council's position is to offer advice and guidance to help clarify, as we've heard, for residents, to clarify the process, the land use process, to give them guidance. Once again, this is not an individual that will be representing anyone, either individually or as a group, at public hearings or public matters, but can in fact testify at hearings on issues to help clarify and help establish a clear and concise record, and can provide guidance. So no, this is not a position that will answer to either the county council or the county executive.
Thank you very much. Okay.
Thank you.
Thank you. This concludes our local bill hearing for the Economic Development Committee. I want to thank again all the witnesses for taking the time to provide testimonies tonight. And I'm going to turn it back over to Madam Chair Plavkovich-Carr. Thank you all.
Thank you, Chair Chi. And before we go to our second committee for the night, I do just want to recognize that Chair Chi has continued on in her role, but we do have a new Vice Chair, Delegate Pam Queen, for the Economic Development Committee. I want to thank Delegate Jared Solomon for his service in capacity as Vice Chair of that committee for the last several years. And then turning to our attention now to the Education, Elections, and Housing Committee, we have a new chair, Delegate Charlotte Crutchfield, and a new Vice Chair, Delegate Lorg Charkoudian, who are serving in new roles there. And I want to thank our former chair, Delegate Emily Shetty, who's continuing on as Vice Chair of our House delegation, as well as Delegate Vaughn Stewart, who had served previously as the Vice Chair of that committee, and thank them for their work. And with that, I will turn it to Chair Crutchfield.
Thank you very much, Madam Chair. So I'm Delegate Charlotte Crutchfield, Chair of the Education, Election, and Housing Committee. So let's get started. We have 5 bill hearings. The first bill up will be MC 1-24. And we'd like to hear from our sponsor, and that is Delegate Kaufman. Delegate Kaufman, you're up.
Thank you, Chair Crutchfield. I really appreciate it, Madam Chair, and I hope all of you had a wonderful Thanksgiving. And I want to echo Chair Plavkovich-Carr's comments about Delegate Shetty, who chaired this committee with distinction. I look forward to working with you, Chair Crutchfield. For the record, my name is Delegate Aaron Kaufman. I represent District 18 versions of this bill. Earlier this year in 2023, 2022 in the Montgomery County Council. Ranked choice voting also importantly has the support of Senate President Bill Ferguson, who was quoted in an article in Maryland Matters in October, in which he said, "I'm almost certain that ranked choice voting is the way to go, but more education is needed. Well, Mr. President, I will be providing that education tonight. Ranked choice voting, or RCV as it is known, is a method of voting in which voters rank candidates by preference on their ballots. This method of voting ensures a fair and more representative outcome by considering a voter's preference beyond their first choice. Ranked choice voting also ensures that candidates nominated within each party have a majority consensus. This method of voting also encourages a more diverse pool of candidates to run within the existing parties, including candidates of color. Ranked choice voting is already used in a variety of states and localities. Alaska and Maine use ranked choice voting in federal and statewide elections. As we may have seen in the news in recent years, 14 states use ranked choice voting in certain localities. In 2024, Nevada and Oregon will have measures on their ballot that address ranked choice voting. So I just think it's time for Montgomery County to get on the train. Ranked choice voting has the potential of most importantly, ranked choice voting has the potential of encouraging more civil campaigns and less corrosive political discourse. Ranked choice voting is catching on in many states and municipalities, and it can open the door for future election reforms that will enhance the levels of democracy. I do want to make one final point, if I can, Madam Chair, and that this is just authorizing legislation. So if the county doesn't want to do it, they don't have to do it, but they seem, based on their testimony, eager to do it. And I know some people have concerns about ranked choice voting that I respectfully think are unwarranted. But Montgomery County, if they have that concern, Montgomery County is a great place to try it and address their concerns. Thank you.
Thank you very much, Delegate Kaufman. Are there any questions from the delegation? Okay, not seeing any. We'll move on to the opposition. And we have Ms. Amy Waychoff. And Ms. Waychoff, you have 2 minutes.
Thank you for this opportunity to testify. My name is Amy Wyckoff, and I have lived in Montgomery County for 36 years. I oppose ranked choice voting, RCV, for many reasons. Just look at Arlington County's experience during the primary election this year. They used RCV, but then abandoned it for the general election primarily because the process is so confusing. According to the board's vice chair, quote, "There are a whole lot of people where maybe their second votes never count. Maybe I don't completely understand it," end quote. One study in 2014 documented a problem called ballot exhaustion, whereby ballots are discarded in the second and subsequent rounds. This phenomenon happens when the voter marks only 1 or 2 candidates. The study concluded that RCV does not ensure that the winning candidate will have received a majority of all votes cast, only a majority of all valid votes in the final round of tallying. For example, Tony Santos, mayor of San Leandro, California, lost his re-election bid in 2010 due to RCV. After the first round, Santos led, but only with 36% of the vote. After 6 rounds, the winner had 51% to Santos's 49% of the remaining vote. The winner held a majority over Santos in the final round, but his share of the total votes cast was 46%, not a majority. RCV is expensive. Last year, the cost of implementing RCV was estimated at a whopping $2 million in Montgomery County alone. 4 years ago, California legislators voted for RCV, but Governor Newsom vetoed the bill because, quote, "the promise that RCV leads to greater democracy is not necessarily fulfilled," end quote. Like the governor, I believe that RCV requires much more study before it is used more widely. Therefore, please give MC 124 an unfavorable report. Thank you.
Thank you very much. And are there any questions for this witness? I don't see any, so that concludes our hearing on MC 1-24. So we'll move on to the next bill, which is MC 3-24, and that is Housing Opportunities Commission alterations, and our sponsor is Madam Chair. Madam Chair, you may move forward.
Thank you, Madam Chair. Good evening, colleagues. For the record, I'm Delegate Julie Polakovich-Carr, here to present MC 3-24. So I think we all realize that we are in the midst of an affordable housing crisis here in Montgomery County. That is true, certainly. It is true in our region, and it is true, unfortunately, across our state. In fact, in Montgomery County, we are short nearly 25,000 affordable housing units right now, and that's according to the Metropolitan Washington Council of Governments. Now, this isn't a new problem, and our partners in county government have been taking a multitude of steps over the years to try to address this problem. There's been a long time requirement in Montgomery County to have a 15% set aside in new housing developments for moderate income families. They've increased funding for affordable housing development. The 2050 master plan allows for more housing near transit, and the county has successfully used the right of first refusal to preserve naturally occurring affordable housing, amongst many other actions. But it hasn't been enough. We still are falling behind in terms of the need for affordable housing in our county. And I really feel like we're at a point where we should be looking at every level of government for what actions that we can take to ease and incentivize the creation of more affordable housing. So the bill that's before you tonight is a fairly straightforward bill that cleans up two provisions of state law that relates to development of affordable housing by the Housing Opportunities Commission. For folks who aren't familiar, HOC is the county's affordable housing agency, and it is also a developer of affordable housing. So the bill does two things. First of all, it repeals a requirement in state law that HOC publish a summary of their annual financial report in two local newspapers. This is actually just duplicative of another part of state law that requires the publication of the entire financial report, not just the summary, on HOC's website. We actually enacted this delegation in the 2020 session. That was legislation that was sponsored by former Delegate Alcar. And I just think in the 21st century that when people are looking for financial information about HOC, I don't think their first thought is to go to the legal notices section of the local paper to find that information. They're going to go online. So the second part of the bill repeals an unnecessary public hearing requirement. And I just want to take a step back and talk a little bit about the development review process, not specific to HOC. So our county's development review process already requires a pre-submission community meeting, as well as a public hearing before the planning board for any submitted development application. So that's two required public meetings. And then additionally, the federal government requires a separate public hearing for any development projects that involve federal tax credits for the creation of affordable housing. So that's two required public hearings and a required community meeting. Well, HOC has a required fourth meeting that has been in state law since 1957. That is kind of interesting in a couple of ways. One, 1957, actually, that predates HOC. So this is a requirement that's been in place for an additional hearing for a very long time. And second, this additional hearing requirement is specific to HOC. Literally no other housing developer or any other developer in the county, whether for-profit or nonprofit, has to have this required additional hearing. So I'm just looking for parity for HOC as with all other housing developers in the county by repealing this particular hearing requirement, since we already have a robust public process that includes two other public hearings and one other public meeting. So I think these are small but meaningful actions that can help streamline the creation of affordable housing in Montgomery County. And I'll just finish by noting that the bill does have the support of the county executive and was supported unanimously by the county council. Thank you.
Thank you very much. We have two more folks that are in support of the bill. The first up will be Chelsea Andrews. Ms. Andrews. Let's see. Ms. Andrews. Calling Ms. Andrews.
Thank
Okay.
you. I am here. Greetings.
Okay.
Greetings. Sorry about that. And good evening, Chair Crutchfield and members of the delegation. I am Chelsea Andrews, President and Executive Director of the Housing Opportunities Commission of Montgomery County. Thank you for the opportunity to speak with you this evening. I am here to share the Commission's strong support for MC 3-24, which would remove the unnecessary barriers to affordable housing in our community. We are grateful for Delegate Polakovich-Carr, who approached us this summer about removing requirements in HOC's authorizing statute that are antiquated and overly burdensome. Thank you as well to co-sponsors Delegates Moon and Stewart. As Delegate Polakovich-Carr has stated, this bill does two things. First, it removes requirements to advertise notices for our annual financial statements in physical newspapers, allowing us to post it online. This requirement imposes a small but unnecessary cost, and removing it does not compromise transparency in this digital age. Second, it removes the specific requirement that HOC hold a public hearing before building assisted housing in the county. Currently, this creates an additional hurdle only when the proposed housing is affordable. For the same reason that Maryland has made it illegal to discriminate based on source of income, we strongly believe that housing should not face additional hurdles simply because the residents might have lower incomes. I want to emphasize, however, that this bill does not eliminate the normal public notice and hearing requirements imposed by the development process, and all of our commission meetings are open to the public, noticed, open to the public, and allowing for public comment, as well as archived on YouTube and live streamed. Finally, we appreciate the county's support of this bill. There is a similar requirement in the county code, and we are engaged with council members on removing that requirement as well. Thank you for your time.
Thank you very much. And our final supporter of the bill is Dan Reed. Is Mr. Reed here?
Hi, can you hear me?
Yes, thank you.
All right, awesome. Hi, my name is Dan Reed. I serve as the Regional Policy Director for Greater Washington. We're a nonprofit that works to advance racial, economic, and environmental justice in land use, transportation, and housing throughout the DC area. And we strongly support MC 324. We believe this legislation will remove a significant barrier to producing much-needed affordable homes by repealing the provision applying only to public housing development, requiring additional public hearings beyond the development review process. This is a 1950s era law rooted in segregation that uses the public process as a tool to keep people out. And communities around the country did similar laws. You know, California famously amended their state constitution to put all public housing projects in the state to a referendum. Included in my testimony, which I've sent to the delegation, are just a few examples of how community members in Montgomery County have applied this law over the past several decades to block or attempt to block HOC projects. And when the state empowers people to block housing in their neighborhoods, we all pay a cost. As Delegate Polakovich-Carr has noted, we have a housing shortage, including a shortage of nearly 25,000 affordable homes. The Housing Opportunities Commission is an important tool for producing affordable housing at scale, as well as increasing the supply of market rate attainable housing. And as has been noted already, their projects go through an extensive development review process, just like any other housing development. We hope the county delegation will support this bill and look forward to supporting it. We look forward to supporting it in the General Assembly this spring. Thank you.
Thank you very much. Are there any questions from the delegation for any of the folks that have just testified? Okay, not seeing any questions. We are concluding our hearing on MC 3-24. We're going to go on to the next bill, and that is Bill MC 5-24. And again, our sponsor of that bill is Madam Chair, and that is the Montgomery County Board of Education Vacancy Procedures Alterations. And go ahead, Madam Chair, if you're ready.
Thank you, Madam Chair. So colleagues, this bill addresses how vacancies are filled on the Montgomery County Board of Education. So under state law currently, anytime there is a vacancy on our local school board, that seat is then filled through appointment, and that selection is made by the remaining members of the board. So it's an appointment process 100% of the time. I think we all understand on a more intuitive level that elections and letting the voters decide who serves as their elected officials is just an inherently more democratic process, especially when a nearly full 4-year term is at stake. And so that's why we see a number of other local offices in Montgomery County that when there is a vacancy, especially a vacancy earlier on in a term, that gets filled through a special election. So that's true for county executive, county council members, but Rockville and Tacoma Park also use special elections to fill municipal vacancies, and the city of Gaithersburg also allows for special elections under certain circumstances. So what this bill would do is it would say that if there's a vacancy in approximately the first 12 months of a 4-year school board term, that instead of an appointment, there would be an election held at the next regularly scheduled congressional election, so the even year elections, to fill the remainder of that term. In the meantime, the Board of Education would still do a temporary appointment, so they're at full force in the meantime until the election happens. But basically, that election process would look the same as it does for regular elections. There's a candidate filing deadline. There'd be a primary if there were a sufficient number of candidates, and then the winner would be chosen at the general election. I should point out and remind everyone that our school board does have staggered terms, so always half the members are up for election on each congressional election, the even year elections. So what this would mean is for a district seat, which we have 5 of on the Board of Education, the highest vote getter in that November general election would win the remainder of that term. So basically the remaining 2 years of the term. It's a little more complicated for the at-large members because we do have 2 at-large members. And because of the staggering of terms, at every even year election, we are electing a new 4-year term for at-large. So we'd still need to fill that seat, but we'd also have the partial term to deal with. So I just want to be clear because I've gotten a few questions on this provision of the bill, but basically the highest vote getter in the general election for the at-large seat would win that 4-year term. The second highest vote getter would win the partial term, the 2-year term. And so I'll note that the specific cutoff in the bill for when it would just be an appointment versus go to election is 55 days before the candidate filing deadline. And that is a date that floats around from election cycle to election cycle. But typically that candidate filing deadline is in January or February in that even year. So we'd be looking at, generally speaking, about 12 or 13 months into a 4-year term would be about when the cutoff would be for allowing for an election versus it would just be an appointment period. So the nice thing about the way that this bill is set up is that it's not a special election, technically speaking, because we'd be talking about filling this seat at the next regularly scheduled election. So there's no additional costs. It would just be an additional office on the ballot. And because it's a regularly scheduled election, there's no concerns about voter turnout. We have very strong voter turnout for our elections in even years. And I think the simplicity of the system is maybe part of the reason why 6 other counties in Maryland have already adopted something similar. Most recently, we passed legislation allowing for a similar system in Frederick County for their school board in the 2022 session. And for those of you who are around for that session, that bill did pass unanimously through the House and Senate. So I think this is a good change we can make that puts our Board of Education better in alignment with other local offices in Montgomery County and just allows for a more democratic process going forward. Thank you.
Thank you. And it looks like we have a couple of questions from delegation members. Delegate Foley, if you'd like to go ahead and ask your question.
Thank you, Madam Chair. For Chair Polakovich-Carr, the sponsor. Well, I guess she's the only one that testified so far.
Yes.
I guess so. It has to go to her. So my question is, so the voting would still be the same as it is in a regular school board election, that is, and these district seats, they would be elected by everyone in the county. Is that
right? Correct? It doesn't change anything in terms of
it doesn't change
mechanics
anything.
of the voting. Yeah.
Okay. And then just to be clear on the filling of the vacancy at the at-large, I think I heard you say that the first vote getter would be the one who, or the top vote getter would be the one who wins the seat that's on the would be on the ballot. That's not the vacancy. The second highest vote getter would be the one to get the seat that's the vacancy. Is that what I heard you say?
That's right. Yes.
Okay. Thank you.
Thank you, Delegate Foley. And Delegate Queen, you have a question as well?
Well, I'm not sure I still have a question, but I was trying to understand this staggered approach that you mentioned. So the school board, they serve for 4 years, but every 2 years we are having an election, right? And that goes along with the congressional election. So if I was voted in the first 12 months of my 4-year term, that's when this would come into play, right?
That's exactly right. So like if the bill was in effect now, anyone who would have been elected in the 2022 election, if that seat got vacated anytime between December 1, 2022, which is when they took office, and basically the middle of next month, then it would go to election on the 2024 ballot.
And so this doesn't impact someone who was already part of this in their 2 years, in their 3rd year, that they wouldn't be impacted by that.
That's exactly right. And actually, like the most recent, if we think back to the most recent appointment that was on the board, that happened in the last year of a 4-year term. So that still would have been an appointment this bill wouldn't have, if it was in effect.
And we would still have the appointment process again?
Yes.
So we're not saving in anything from that, though. The appointment process is, I guess, is where we're concerned that we're not being as democratic as possible. So I guess we haven't solved that problem in that case.
Right. There would still be appointments under this bill.
Okay, thanks.
Thank you, Delegate Queen. Delegate Kaiser, you have a question?
Yes, thank you, Madam Chair. Appreciate it. Delegate Plakovich-Carr, Chair Plakovich-Carr. My question's a follow-up to what Delegate Foley was asking you. So, excuse me. I know that currently when we do our school board elections and our primary, no matter how many multitude of people run, 2 people then advance to the general in each of the races, and then 1 person wins. Are you foreseeing that in this case, that that if for any of the district seats, or I guess for the at-large seat, sorry, if it were an at-large position and then there was another at-large race happening at that same time, of course, as there always is one of them, are you foreseeing that 2 people advance from the primary to the general, and then at that point they are the only 2 then competing for the partial term and the full term?
There would be 4 people advancing from the primary. So thank you for that question. What the Board of Elections has told me is there's a primary if it's basically double the number of seats plus 1 that has to be filled.
Okay. Any more questions? All right, we'll move on to the other 3 supporters of the bill, and we'll start with Ms. Susan Albertine.
Yes, Susan Albertine.
Thank you. My apologies.
Oh, no problem. I'm the president of the League of Women Voters of Montgomery County. The League of Women Voters of Montgomery County, Maryland, takes this opportunity to express our support for MC 524. We support the bill's proposed mechanism of filling vacancies on the Montgomery County Board of Education to ensure the body is fully staffed to carry out its obligations and to ensure voters are fairly represented by the board's membership. It is the position of LWVMC and the entire League of Women Voters of Maryland that special primary and special general elections to fill vacancies in the Maryland General Assembly be held at the same time as other regularly scheduled elections, that is, tie-in elections. We also believe it is important that election systems produce representation that reflects community sentiment, help increase voter participation by encouraging a broader range of candidates and more civil campaigns, and are feasible to implement. It is in this spirit that we support the bill's proposal to extend the practice of special tie-in elections to county boards of education. We would like to suggest an amendment to the bill's language, specifically section 3901 F5. We suggest that in the event a vacant position is filled at the next general election, that ranked choice voting, RCV, also known as instant runoff voting, be used. We support this practice for state and local elected positions and believe doing so at the time of a general election would increase the chances for voter participation in the special tie-in election. With the Montgomery County delegation's support, we hope to see MC 524 advance to the entire General Assembly for consideration and action. Thank you for providing the public for this opportunity to give input on this bill.
Thank you very much. And our next person up with testimony is Cynthia Rubenstein.
Good evening. My name is Cynthia Rubenstein, and I am the advocacy co-chair for the Montgomery County Women's Democratic Club. WDC recently established an advocacy subcommittee called Advanced Democracy in Maryland, with the mission of making Maryland a national model of democratic reform and voter engagement. In that spirit, WDC strongly supports MC 524, which under certain circumstances would require special elections to fill vacancies on the Montgomery County Board of Education. We appreciate Delegate Polakovich-Carr's sponsorship of this important legislation. Currently, sitting Board of Education members fill vacancies by appointment. Thus, only 8 people determine who completes a Board of Education term, which can be up to nearly 4 years long, depending on the timing of the vacancy. This absence of citizen input in democracy is not acceptable. As the sponsor testimony notes, by aligning the special election with the next congressional election, MC 524 resolves 2 objections that are often made to special elections. Number 1, the cost, and number 2, the potential for low voter turnout. Some claim that appointments allow for greater diversity in elected bodies. However, we need only examine that the composition of our current Board of Education and our county council and legislative delegation, for that matter, to see that Montgomery County voters have no problem voting for women candidates, candidates of color, and LGBTQ candidates. We do not need to deprive voters of their franchise to ensure that our county's governing bodies reflect our county's diversity. It is past time for our elected officials to increase the countywide and local offices in which midterm vacancies are filled by special elections. It is past time to respect the 85% of Montgomery County voters who in 2014 supported a constitutional amendment to use special elections to fill a county executive vacancy. It is past time for Montgomery County to join the 6 other Maryland counties that use special elections to fill certain vacancies on their boards of education. We are lagging behind and failing our voters, and we need to catch up. Thank you very much.
Thank you. Next, we have Michael DeLong.
Thank you very much. My name is Michael DeLong. I'm the president of the Montgomery County Young Democrats. We are a club of young Democrats ages 14 to 35. We work to make Montgomery County and Maryland better places to live, to elect Democrats up and down the ballot, and to get young people involved in politics and advocacy. And elections are an essential part of that. So we urge your support for this bill, MC 524, which would require special elections when vacancies occur on the Board of Education in the first year of a board member's term. You've heard it before, but it requires that if there's a vacancy on the Board of Education occurring 55 or more days before the candidate filing deadline for the primary election, that a special election for this position be held at the next general election. We strongly support the expansion of democracy and the right of people to choose their elected officials. In the past, we've testified in support of reforming the process for filling vacant Senate and delegate seats by holding special elections whenever possible. And Montgomery County, to our credit, we have special elections to fill vacancies for other local offices like the county executive and the county council. But the Board of Education vacancies are currently still filled via appointment, and this deprives Montgomery County voters of opportunities for input and to choose important policymakers. So school board members oversee the education of our future community members. They set the vision and direction of our local schools. They pass annual budgets, write policies for teachers, kids, and staff, work to ensure schools are equitable, and perform many other tasks. So by supporting this bill, the Montgomery County delegation and the Maryland legislature You have a chance to expand democracy in the county to ensure that Board of Education members are more connected with their constituents. And it's a pro-democracy reform that will strengthen the county, make the Board of Education more responsive, and it will bring Montgomery County in line with several other Maryland counties as mentioned. So it will also benefit our students and everyone in the long run. So we urge your support for this bill. Thanks again, and please contact us at mocoyoungdems@gmail.com if you have any questions.
Thank you very much. Are there any questions from the delegation? Okay, not seeing any. That will conclude the bill hearing on MC 5-24. We will go on to the next bill, which is MC 8-24. And our sponsor on that bill that we will hear from right away is Delegate Moon.
Thank you, Madam Chair. MC 824, in short, is an attempt to stop private entities and individuals from attempting to overrule local zoning in Montgomery County. This is commonly done through HOA covenants and deed restrictions that basically mean at some point in time, decades ago, someone got together and inserted clauses into deeds that would block people from building legally permitted housing types that are explicitly allowed by local zoning, even decades later. So if you check your email, I've sent around a link to a project from Montgomery County Park and Planning. For the online audience, you can Google Park and Planning Mapping Segregation Project. And what you will see is that they have attempted to map where these restrictions on housing have been placed, and it's fairly widespread throughout Montgomery County. You'll see from the map that this is basically only looked at thus far through 1953, and a lot of these came into existence in Montgomery County in the 30s and 40s and are still in effect. The language of them varies, but they all say something to the effect of, no matter what's going on, you can't build anything but single family house here. Some of them say specifically, you can't have an accessory unit or something like that. And as many of you know, Montgomery County very recently liberalized the right of residents to build accessory apartments throughout the county. They have also at the county level specifically said in the permitting process, we do not recognize an HOA or covenant objection to accessory dwelling units in particular. But that backstop does not stop someone from suing a homeowner attempting to exercise their local zoning rights, and does not stop HOAs from levying fines or other obstructions that can either harm the financing of these residential projects or lend some unpredictability, added costs, or delay to what's going on. I will admit this is not a brain creature of mine. It was actually inspired by an effort that is going on right now in Washington, D.C., where Ward 3 council member proposed a bill to invalidate racial covenants and housing type restriction covenants, which this council member noted came in at the same time. And you can surmise some of the purposes to these deed restrictions. So having said all that, the language you see online for MC 824 is a placeholder. It is very broad, and we are working on amended language that would basically restrict this to what I have described, and would also attempt to create an exemption for people trying to dedicate land for charitable purposes, to build a school or a park or things of that nature. But otherwise, my proposition to you, colleagues, is that we should not allow residents, neighborhoods, individuals to get together and decide that they are overruling the county and local zoning processes that have been undertaken with quite a bit of thought. And as you've seen already, we have layers of process that people are already debating and or struggling through. So let's let that be what it is and not have micro neighborhood zoning happening through the back door through these HOA covenants. So I will leave it there. I hope to take this into a work session where we can explore this in greater detail. And with that, I am happy to answer any questions.
Thank you very much, Delegate Moon. And are there any questions from the delegation to the sponsor of the bill? Okay, seeing none, we will move forward with the testimony of two others that'll provide supporting testimony. And we'll start out with Dan Reed.
All right, thank you. Hi, once again, my name is Dan Reed. I'm the Regional Policy Director at Greater Washington, and we strongly support MC 824 as a way to facilitate housing production while also remediating longstanding socioeconomic and racial segregation in Montgomery County. As has been noted, this would prevent HOA bylaws or deed restrictions from blocking housing types that are already allowed by Montgomery County zoning, such as multifamily homes, basement apartments, or accessory dwelling units. This has been something communities in Montgomery County have used as a form of exclusion for decades. Even after the Supreme Court struck down racially restrictive covenants in 1948, there remain covenants that prevent the construction of housing types deemed undesirable. One example is a neighborhood in Silver Spring called Woodside Park, which was built in the 1920s and 30s, and the homes came with covenants barring modest homes that cost below a certain amount. And the original developer even went so far as to sue one of the home builders working there for building homes that were too cheap in appearance and actually forced him to make the homes more expensive. So these covenants, while that seems like a long time ago, have real consequences, right? By restricting land in high demand, high opportunity communities to like high cost homes, they price out working people and force them into further out areas. That contributes to suburban sprawl, which in turn exacerbates racial and socioeconomic segregation, traffic congestion, environmental damage, and importantly, stress on our tax base. Private neighborhood associations should not be allowed to circumvent county laws to the detriment of all county residents. In closing, we urge the county delegation to support this bill and look forward to testifying in favor of it at the General Assembly as well. Thank you.
Thank you very much. Next, we have Mr. Mike English for 2 minutes.
Thank you for agreeing to hear my testimony. Mike English in downtown Silver Spring, various affiliations, none of them pertaining here. This is me as myself. Strongly urge the delegation to support this bill and do all it can to facilitate its passage. Montgomery County has been making progress in changing exclusionary zoning laws. I'd like to go further, but it still deserves credit for progress made. But this bill is important because without it, as was alluded to before, HOAs or similar associations could undercut zoning reforms that would allow apartments and other multifamily housing as they have in the past, and which are cheaper housing and house a lower income population than detached homes, both nationally and in Montgomery County. DC has undertaken similar legislation, as Delegate Moon said, so this is an uncharted territory. And single-family zoning and racial covenants came about largely as tools to perpetuate segregation. And even the most benign-sounding covenants or other measures can be utilized to perpetuate the harmful status quo. One of the early Supreme Court cases that established and reinforced single-family zoning, Euclid v. Ambler, noted, and I think this is relevant here, and I quote, "Very often the apartment house is a mere parasite, interfering by their height and bulk with the free circulation of air and monopolizing the rays of the sun, which otherwise would fall upon the smaller homes, until finally the residential character of the neighborhood and its desirability as a place of detached residences are utterly destroyed." That is how innocent-sounding language about neighborhood character and community fit can and have been weaponized to keep undesirables out. That is treating people that can't afford the most expensive type of housing, which single-family detached homes are, as pollution. And organizations made up of people that cleared these discriminatory barriers should not be able to unilaterally perpetuate that exclusion. That's what makes this bill so key. As I said before the same body a few weeks ago during the delegation priorities hearing, the state can and should play a more active role on land use and zoning decisions, precisely because the same local groups have more influence at the local level. And the county, for all the strides, has not taken action yet.
Mr. English, your time is now up. Thank you.
Just
so
wrapping
much.
up anyway. Thank you.
Thank you. Next, are there any questions from the delegation to either Mr. English or Mr. Reed? Okay, seeing none, we're going to move on to those who are in support of the bill with an amendment. And we'll start with Chairman Artie Harris.
Thank you so much. Can you hear me okay now?
Yes.
Okay, so thank you, Madam Chair. Good evening. Again, I'm Artie Harris, Montgomery County Planning Board Chair. Thank you for this opportunity to testify on this bill on behalf of the Montgomery Planning Board. We strongly support the concept of this bill. Our planning board established a few key priorities and areas of focus earlier this year, with our top focus working towards accelerating housing production and access in the county. Based on our understanding of the intent of this bill, it does just that. Bottom line, we do not have enough housing, nor are we developing enough housing at the necessary rate to provide affordable and quality housing to current and prospective county residents. The planning department and board are working to implementing many tools to streamline development review and keep the pipeline moving. However, we need bills like this to prevent deed restrictions outside of the zoning regulatory process, which unnecessarily limit potential housing development. We do have some recommended amendments to ensure there's no ambiguity in this bill, which Deborah Borden will detail. With our proposed amendments, we request a favorable vote for Bill NC 8-23. Thank you.
And thank you. Next, we will hear from Deborah Borden.
Thank you. Good evening, Committee Chair Crutchfield and members of the delegation. I'm Deborah Borden, General Counsel for the Park and Planning Commission. We definitely support the intent of this bill, which is to add housing supply to the county by implementing permitted zoning that allows innovations such as ADUs or accessory dwelling units, for example, and disallowing HOAs and condo associations from prohibiting them in spite of the zoning. We believe that the first draft of the bill, though, is a bit too expansive because it includes every conceivable real property instrument. It includes deeds, easements, and even mortgages. And this might raise too many questions about the expansive approach, and we're concerned that it's going to cause too many unintended consequences and impact all kinds of things that are well beyond the intent of the sponsor. So we do support the bill with amendments that would tailor the bill to focus on those declaration of covenants that you've heard previously in previous testimony that are recorded by HOAs and condo associations that limit the use of residential property in ways that are allowable pursuant to the applicable zoning. In this way, the zoning innovations that we are working so hard to implement, which we hope will result in additional affordable housing in the county, will not be thwarted by private covenants to the contrary. We have already reached out to the sponsor, and we look forward to assisting and supporting an amended bill. I hope you'll consider these points as you make your decisions on this bill. We are happy to answer any questions you may have, and thank you for your time this evening.
Thank you. And are there any questions for the two previous folks who have testified? And I don't see any, so that will conclude the hearing on MC 8-24. And we will move on to our last bill for the evening, and that's MC 13-24. And that is on Montgomery County Juvenile Law Truancy Reduction and School Reengagement Program. And is Senator King in the room? See, Senator King. Okay, is Judge Dumais present?
Yeah, Senator King is here.
Oh, is she? Okay.
Yeah,
okay.
I just had to find my video button.
No problem. Thank you, Senator King. Please go ahead with your testimony.
Okay, nice to see everybody tonight. Okay, my bill has to do with the truancy problem that so many people are talking about and trying to find ways to solve the problem. And it's not just Montgomery County, but it is all over and growing. So I've been working with my good friend Judge Dumais, our former delegate, and John McCarthy, the state's attorney. I've had several people looking at this. So anyway, we're introducing truancy reduction and school re-engagement program legislation as another way for our school system to partner with our courts to help our students re-engage in school and receive the education that they well deserve. With me tonight, I do have Judge Dumais on my panel, who is currently sits as the juvenile delinquency juvenile delinquency judge, and can share with you the importance of this program. And along with Judge Dumais is Magistrate Althea Stewart Jones, who presides over Prince George's County Truancy Court, and Kendall Timmons, the Regional Program Manager for the Truancy Reduction Court Program in the 1st Judicial District, Dorchester, Somerset, Wycomico, and Worcester counties. Both of these women will share with you the successes that they have seen with the truancy programs and that they have implemented in their counties. So who was, I guess, Judge Dumais, are you first on the list here?
Yes, Judge Dumais is the first on the list. Would you like to pass it on to her now?
Pass it on to her.
All right.
Nobody better.
All right, Judge Dumais.
All right, well, thank you. And it's so nice to see everybody. It's been a while. So I am here to support MC 1324, primarily from my perspective, based on I've been sitting as the juvenile delinquency judge here in Montgomery County since July 1st. We do these rotations on the circuit court, and they're for a year. So I will continue to sit in juvenile until July of 2024. I have to admit, it's been an assignment that was different for me, but I actually really enjoy it. There's some really difficult cases and very sad cases, but then there are those nice ones that you feel like you've made a difference. And I had a variety of them today. But the last one was a young man that has had a fentanyl problem and went through the process and is doing well and is attending school, which is good. But the number of youths that I see every day that simply don't go to school, I mean, it's just astounding to me. It's sort of it's a new thing with this younger generation. And although this is a generalization, many of the youths that fail to attend school are often involved in the more serious crimes or offenses. And unfortunately, their truancy has been very long-standing. So the scope of the problem is staggering. And as you all know, MCPS has over 168,000 students. And as recently reported by WTOP and the Washington Post, the percentage of students who are chronically absent, that is, they are missing more than 10% of the time for any reason, is 21.4% in Montgomery County. That's 34,161 students. In Montgomery County, we have 27 high schools with around 52,000 kids. We have 40 middle schools with around 37,000 children. We have 137 elementary schools that have about 68,000 students. And we have another approximately 10,000 in five special schools and alternative programs. The program that's being proposed in this legislation is not a silver bullet, but it's another program to address the need to re-engage youths in school. The Montgomery County State's Attorney's Office, as Senator King indicated, has an excellent program that's been in effect since 2010. And as noted on their website, it is up and running in 19 middle schools in the county, with 7 to 10 students in each program. 6 schools will be added to that program this spring, 4 more in the fall. When all of the schools are included, the total number of students in the program will be approximately 300. Again, I said we have 34,000 that are chronically truant. The goal of the program outlined in the bill will be to supplement and complement the existing program in the Office of State's Attorneys. MCPS also has specific programs in place, launched a number of initiatives at the beginning of this school year to address this problem. However, everybody seems to agree we need more programs to address the issue. This bill is enabling legislation. It will allow the court to work with all of the stakeholders and design and implement a program. Finally, let me be clear, the State's Attorney's Program, the goal is not to prosecute parents. It is to be a problem solving for families and school system. The next speaker is someone that will be able to tell you about how it's implemented in Prince George's. Magistrate Althea Stewart Scott.
Thank you, Judge
Jones
Dumais.
has done it for a while. So
Thank you very
she's
much, Judge.
probably the best. Thank you.
Can I add something here quick?
Hold on for a second, Senator King. Just hold on. Let's let Magistrate Stewart go ahead and Stewart Jones speak, and then we'll come back to you if that's okay.
Okay.
All right, Magistrate Stewart Jones.
Thank you, Chairman Crutchfield. Good evening, everyone. I am Althea Stewart Jones, and I've been a family magistrate in the Circuit Court for Prince George's County for over 16 years. This is my 14th school year presiding over our Truancy Reduction Court program. In addition to presiding over Truancy Reduction Court, I handle our child in need of assistance, which is our child abuse and neglect cases, as well as some of our delinquency cases. I believe that my dockets in those two case types, especially in the delinquency docket, would increase if we did not have a truancy reduction court in our county. Our students and families are referred to us from our school board, specifically our education liaison. These students and families come to me with pretty much the same problems and difficulties as my center and delinquency dockets. However, the approach to working with these families is quite different. Problem-solving courts focus on understanding and addressing the root causes of the problems. Students often do not go to school due to issues at home, such as caring for family members, undetected or undiagnosed mental or physical disabilities and impairments. Our truancy court coordinator and case managers are in weekly contact with the youth and families and provide support and referrals for services. At the beginning of them being adjudicated in our truancy reduction court program, I see them at least once every 2 weeks until they start making improvements. Then it's once every 3 weeks, every 4 weeks until they graduate from our program or leave our program for other reasons. Research shows that our truancy kids are at high risk for delinquent behavior, unwanted pregnancy, high school dropouts, and other maladjustments. We provide those services for them. Those services and supports include tutoring, parent support groups, pro-social activities, referrals to community-based resources that address anger management, case management, mentoring, substance abuse, and other mental health counseling. One thing that people ask about is whether this is what they call a school to prison pipeline. And of course, it does just the opposite. Instead of our students going further into the juvenile justice or criminal court systems, we have been able to direct them away from those criminal justice or juvenile delinquency systems by engaging them in mental health services, substance abuse counseling, mentoring, and tutoring programs. And we've just prevented some of our youth from being adjudicated delinquent. Since the inception of our truancy reduction court, we have 155 graduates. While we are proud of that accomplishment, that doesn't tell the full story. There are many of our youth, our students, who do not meet the rigorous requirements of our program, but we have helped them become better at attending school, get better grades, and again, avoid getting into delinquent behavior. By providing structure, support, and services, the parents are able to discipline their children appropriately and be more accountable. Both the students and the parents are better able to advocate for themselves. Again, not all graduate from our program, but they are better served by being in school, making better grades, and looking forward to a future, having goals.
Thank you very much, Magistrate. Appreciate it. Senator King, you had a comment or question?
I had a comment. I just wanted to, some of you on here might remember last year, this was a statewide bill, and it was voted on in the House, I think it was March 19th. Anyway, it didn't get enough time to really go through the whole process and have the Senate pass it. So we have decided this year to try it as a local bill. I'd be just as happy to make it a statewide bill. If there seems to be interest in that, we will absolutely switch it over to be a statewide bill. But just wanted to let you know it's not a totally new bill.
Okay, thank you very much. I see a question from Delegate Cullison.
Thank you very much, Madam Chair, and thank you, Senator and Magistrate and judges who are offering this program. I have I really support the concept and the and the mission of the program. I'm wondering about funding. How is it? How is it anticipated to be funded? Because it seems like it's providing good resources, which like I said, totally support. Just wonder, if there's been any thought around that. Is it coming from local funding, state funding? Where do we see that?
The bill as drafted talks about state funding, but I have to admit there is also grants that are available for things along this line, and that would really be sort of the impetus for it. So we're aware of that's a very tight state budget, and would certainly be looking for grants. And when we're looking at the services, a lot of times it's referring individuals to services that are already in existence. So it's not creating new services that don't already exist. Yeah. So it's a combination of things, and I hope that answers your question. I don't know if Magistrate Jones has any further comment.
Yes, I was gonna say it's state funding, and we provide some services ourselves through the court system, such as tutoring. We have a separate GED program as well, but a lot of it is tapping into the community services that already exist.
Great. Thank you very much. I really appreciate your work on this.
Thank you. And Madam Chair, you have a question as well?
Thank you, Madam Chair. Judge Dumais, great to see you. Magistrate Stewart-Jones, thank you for being here too. I just had a question in regards to, so what happens for the students who aren't successful? Magistrate, you mentioned that. Is there consequences, or is it that the court just keeps them in the program longer? Can you speak to that?
I'm sorry, could you repeat that? I'm having problems hearing you.
Okay, hopefully my internet here is stable. I'm wondering what the consequences are for students who are not successful in the program. You mentioned that, not everyone graduates out. And so what does that look like for the students who are not meeting, say, what is being expected of them or ordered of them and their families?
They don't graduate for different reasons. Some of them transfer jurisdictions. Some of them reach the age of 18, although we focus on middle school kids. If a student is close to 17 and they say they want services, then we take them. So they may age out. A lot of them, we consider it graduation, but it's not the typical graduation. They go ahead and get into our GED program. And so they do actually get a high school diploma. And then some, we close them out. At a certain age or a certain time in the program, and they decide they just don't want to participate anymore, we provide them resources, again, referral services, especially for the parents. And some of it is just, they come to us homeless. They come to us for a lot of different issues. So food insecurity is a big one, especially since the pandemic. So once we actually address why they're chronically truant and they want to stop for whatever reason, again, because of their age, some of them need to get jobs to help support their families. We just try to provide them resources.
Okay, so just to be clear then, so like if they choose to leave the program, that's their choice. There wouldn't be any punishment or court fines or any kind of negative consequence on the student for leaving the program?
It depends on their age. And if they're not making any progress, the parents just aren't being cooperative, the students aren't being cooperative, then the Board of Education, as well as our program, we can refer them to the state's attorney's office, and they can go that route if it's in fact the parents that are just being neglectful, basically.
Okay, thank you for that clarification.
Okay, we're going to hear from the last witness in support of this, and that is Kendall Timmons. Go ahead, Ms. Timmons.
Delegate Crutchfield. My name is Kendall Timmons, as I was introduced, and I'm honored to testify in support of MC 13 and the expansion of truancy reduction and school reengagement problem-solving courts to include Montgomery County. These specialized courts have emerged as a beacon of hope, instigating positive change through a distinctive and effective approach to addressing truancy. Truancy problem-solving courts distinguish themselves by their commitment to understanding the root cause of truancy, moving beyond merely punishing its effects. Embracing a holistic and therapeutic approach, these courts recognize that truancy often stems from underlying issues, as Magistrate Stewart-Jones has already said. We address family dynamics and family problems, mental health challenges, substance use, homelessness, and among a myriad of other causes. This unique focus on identifying and addressing these core issues allows for a more comprehensive and compassionate resolution. Our team of case managers in the First Judicial Circuit, funded by grants from Maryland's Administrative Office of the Courts, completed over 18,000 individual contacts and case planning activities in fiscal year 23. These interactions involve families, service providers, and treatment agencies, all supplementing the efforts made by our local school staff. These collaborations serve as a bridge for more successful communication with families and schools in the future, ensuring that each family's issues are thoroughly understood by their local school and school system. Through fostering this communication and collaboration among diverse stakeholders, everyone involved is ensured a voice in the process. This collaborative effort creates a supportive network that guides the youth towards success, both academically and personally. The 238 youth and their families involved in our program in FY23 were the subject of over 600 individualized referrals for external services covering areas such as housing, recreation, community mediation center services, mental health treatment, substance use treatment, transportation, and vital records obtainment. Truancy problem-solving courts break away from the perpetuating a punitive cycle that often leads to disengagement from education. Instead, they focus on the rehabilitation and building relationships to foster the communication I mentioned before. We employ a 4-phase program model where we are able to celebrate both small and significant achievements with families. These celebrations are marked with certificates, courtroom applause, and various incentives and activities for the youth. Our staff and presiding family magistrates undergo training in mental health first aid, trauma-informed courtroom practices, motivational interviewing, and mediation. This equips them to meet families and youth where they are and help them to progress through the phases. By providing support and resources to parents as opposed to resorting to incarceration and fines, the court system contributes to creating a stable and nurturing home environment. This approach reinforces the positive change.
Thank you very much, Ms. Timmons. So before we move on, I'd like to just mention that there are several other folks here in the room with us that represent the Maryland court system who are here for questions as well. And that is Kelly O'Connor, Suzanne Pels, Matthew Pipkin, Sarah Kaplan, and Richard Barton. So with questions next, we have other people here as well that can have that expertise in this area and can help us. I'm going to go ahead and call on Delegate Pam Queen. You have a question?
Yes, thank you, Madam Chair. Just a quick question, I think, for Ms. Timmons. You mentioned these courts exist. So is Montgomery County the only large jurisdiction that doesn't have the courts, or where else are they operating in Maryland?
There are a bunch of different options that are available throughout Maryland. We have established truancy problem-solving courts in Harford County, Prince George's County, Kent County, Dorchester County, Worcester County, Somerset County, and Wycomico County, Maryland. So we would welcome the addition of the large Montgomery County.
Okay, so not Baltimore City or Baltimore County or Anne Arundel.
Baltimore City has a different program that does not operate in the court. Anne Arundel County also has other problem-solving interventions for truancy as well.
Thank you. And Delegate Foley, you have a question as well?
Yes, thank you, Madam Chair. My question is for Senator King, I think. Have you, where is the MCPS on this bill? Is MCPS supportive? Have you talked to them about it?
The board has not taken a vote on it yet, but they were pretty supportive of it last year, and they already have programs going in the school system at this time anyway. So I don't have a definite yes or no from the board itself.
Okay, thank you.
Thank you. Any other questions? I have a question. Judge Dumais, I want to just make sure that we understand that there are currently 2 programs, if I'm not mistaken, operating in Montgomery County, dealing with truancy around children. Can you tell us what the difference would be between what you are proposing in a problem-solving court that will be housed in the juvenile court system that is different from what is already being done? Because I understand all those other avenues also provide wraparound services, connections with services, and in particular deal with families. And I know with the state's attorney's office, I do believe that they have a board that when it comes to a point where a child is shown to be a abuser, I'll put it like that, of truancy, that the parents and the family can go before the board and then decisions can be made prior to any prosecution. So can you tell us what the difference is?
Sure.
And then can you tell us kind of also what the loss is around this as far as parent involvement with truancy?
Well, I actually think Magistrate Jones, Stuart Jones, can answer it as well as sort of how it's done in Prince George's, but we would probably model Prince George's. This is not intended to be punitive. This is not intended to sort of only address the kid. I address the kids when they are in the juvenile delinquency system. And that's what I do every day, all day at the moment. This is sort of a separate, it would be like an additional piece, but it would involve the families. There's absolutely no question that this is really intended more as a problem-solving court, similar to what we have with drug court and mental health court. It's not intended to be punitive. Someone comes, they're referred. Usually the way it would work is they would be referred by the school system that they think that the problem-solving court could help this family. And we would then meet with the court would meet with the family. We would talk to the family. We don't need attorneys. It is really more sort of in a mediation fashion. We would work with the state's attorney's office. That program's a little different. They have volunteers that meet with individual children. And as I said, for each of them, now 19, and it will be more, and they want to do all 40 schools, they do about 7 to 10 kids per school. This would be something that the school system could use to send the kids to us, and we would then be able to offer the services. School system can do it, but again, some of it is the numbers. We have 34,000 kids that are deemed chronically absent. And I think the more services and wraparound things we can do, the better. Some kids might respond better to coming to a court and knowing that you have a sense of, and the families as well. We are out there to help them. We are not out there to punish. And that's, we're not filing charges. And in fact, I know in Prince George's County, for instance, the filings are not even done through the court system. And obviously, magistrate will correct me if I'm wrong. It doesn't go through the court system. It's sort of a separate case manager that accepts the files. So it doesn't even get into, something that you could Google on case search. So, we would have to have meetings with stakeholders to talk about what the program would look like. When you heard from Ms. Timmons and heard from the magistrate, each county does it a little bit differently. But given my, when I was asked about this bill by the judiciary, I did jump on it, partly because of what I see every day. Now, a lot of the kids that are before me for juvenile delinquency aren't going to be in the problem-solving court. The idea is we get them before they get to me, before they have committed a crime, and are then in the juvenile delinquency program. This is the school system working with the courts to try and get to them before they get to juvenile delinquency.
Understood. But I also understand that that MCPS also loops those children or provides the children for intake into the state's attorney's program and all the other programs as well.
I'm just trying to expand the numbers.
Okay. And again, you do not believe that you'll be duplicating in any way the services that are already being provided, with the only difference being that now the services you're attempting to provide are through the court system, which in some cases can be a very harrowing experience and terrifying to children and parents, and especially parents who are undocumented as well, because people do shy away from the court system based on that. So that is a concern I personally have, because I know that most of the children that are affected by truancy in MCPS are brown and Black children.
I agree. That's what the numbers show. But I will tell you that one of the articles and there have been a bunch of articles just in the last 2 weeks, partly because John McCarthy was before the County Council Public Safety Committee to talk about his program. But Mike Durso, who's a former principal, made it very clear that more programs are needed. And, like I said, it's the numbers. 34,000 are chronically absent. And although I love the state's attorney's program, and in fact, I have volunteered to be involved in it.
Well,
at best, they're going to be hitting 300 kids.
Well, Judge Dumais, I agree with you. More programs are definitely necessary. I just want to make sure that we wouldn't be duplicating the same kind of services going, for the children that you are also attempting to do through the problem-solving court, which would be in the juvenile court.
Be in the juvenile court, but it would be as a problem-solving court, which means I have no authority to punish the kids, nor should I have the authority. No authority to do any detention. It is really trying to solve the problem before they get to the juvenile court. That's the idea behind this.
But you would still have discretion, right? You would still have discretion to do some of those things if you wanted to.
Absolutely not under this program.
Okay. Thank you very much, Judge Dumais. And I see Delegate Charkodian.
Thank you, Madam Chair, and thank you, Judge Dumais and friends, everyone, for being here to discuss this really important issue. I'm still trying to wrap my head around, I'm fairly familiar with problem-solving courts, and I think in most problem-solving courts, drug court, at least mental health court, one in the adult context, one has to plead guilty and then essentially be sentenced into those systems, and then it's essentially serves like diversion, but it is diversion after a guilty plea. And I think you're saying it's a problem-solving court, but really it's different from all the other problem-solving courts that we have in the state. Is that right? Because you're saying you don't plead guilty. So
we don't get to it, in juvenile, the term is whether they're involved in a crime.
But the equivalent.
I'm not handling crimes. I'm just going to be, and it may be me, it may be some other judges as well. The idea is the school system refers kids to the program. And then the judges would meet with them and sort of talk about with the families, what's causing the issue? How can we address it? What can we do to help? Before they get to, no Department of Juvenile Services is not involved. They aren't in this bill purposely. So it is really designed to be a service. Maybe that's a better description. It is designed to be a service. And again, Magistrate Jones, please interrupt me since you've been doing it. You're probably a better person to answer.
Yes.
Do you want to comment, Magistrate Stewart Jones?
Yes, I do. I guess going back to Chairman Crutchfield's question as well. Our Latino population in Prince George's County has really grown over the years. And so one of the things that we recognize is that there is a language barrier a lot of times within the school system, although they have the interpreters and they have actually staff that speak Spanish, the parents were not getting there. So they weren't really understanding the laws. They weren't really understanding what was happening, why they were called because their child wasn't going to school. So we hired a bilingual case manager that over the past few years that has helped us tremendously to help them understand what the laws were regarding education, help them get services they need, even though they may be undocumented. There are a lot of programs out there that do provide services, whether it's food, whether our court especially provides transportation. So yes, there are most of my docket are the brown and Black children and families. But I think our truancy reduction court really helps them instead of going down the path of dropping out of school. We've really made a lot of progress, especially with our GED program. When we see that a student is struggling, a lot of times they are working, trying to help the family. We provide that program. We provide transportation to the court so that they can participate these 2 days in person, 3 days online, after hours so that they can still get a diploma. Most families want their children to get a high school education, so they are willing to put in the work, but they have to understand the work and they have to have people to meet them where they are.
Thank you. And did you have a follow-up, Delegate?
I did. Thank you, Madam Chair. Yeah, so I guess what I'm just trying to understand is I understand the idea of when someone is sort of involved, and I'm thinking out loud, but giving you a chance to answer just because we're going to have to work on this bill and figure out what parts of it we move forward. I understand the idea of when someone is involved in the court, so charges are pending, and then the courts are creating an alternative within the context because they can't just drop the charges, or I guess they could, but they can't just, you know, for whatever reason, there's a decision not to drop the charges, to use it as an opportunity to intervene. I guess what I'm trying to understand is if we do, I would agree that we need a program. I would agree that we need a program that does wraparound work. I would agree that all of the services and the way they're brought together in this context is really important. I'm just struggling to think that the best place to do that is the court, where there's also the opportunity for charges and, you know, and all the other things that come with adjudication in other contexts. And so it seems like you could do all of these same things, only do it in the context of the schools or another nonprofit or some other context. And I'm having trouble making the connection of, given that it's not within the context of charges, or I apologize for not knowing the juvenile terms as well,
okay,
why it fits in the court and how that becomes an advantage as opposed to potentially a disadvantage that is, you know, alienates or traumatizes or is frightening for people.
First, the program is totally voluntary. Families can leave the program whenever they want, as can the children leave the program whenever they want. It is really offered as a service before the kids get any deeper into, or God forbid, commit a crime and then jump into the juvenile system. This is trying to address just truancy. And so it's, you know, middle school is a good place to start. It's the reason the state's attorney's program addresses middle school, because the idea is we can get them, and yet at the same time, we really need help in the high schools. And that has been indicated in several of the articles that have been produced over since August. And it's something the school system would want is, you know, how do we address these high school kids? Again, you know, you're right. They can be referred by the school system, decide I don't want the services. Okay, fine. I think there are a lot of people out there that would be happy to, and sometimes if it's a child that might be, how do I say it? Not following instruction in the home, maybe the parents are like, maybe coming before the court is a way to have it be formal enough that we can provide it. But it's voluntary. This isn't, okay, if you don't do what you're told, I'm going to send you to the juvenile system. The only way they get into the juvenile system is if they commit a crime. That is not what is going to be before the problem-solving court.
All right. I think it's more conversation. I'm interested in this question of where does this kind of wraparound program belong best? Like, how do we best serve kids? But I appreciate the thoughts and look forward to continuing our conversations.
Thanks.
Thank you. And Ms. Kaplan, did you want to address the question as well?
I did, and I think Judge DeMay did point that out. But I just wanted to repeat, these cases are filed by the court system. I'm sorry, by the school system themselves. It's filed by the school. The laws that this around are court's articles, Title 3-8C. Petitions are filed by the court. They're not filed by the state's attorney. They're not filed by the Department of Juvenile Services. They're filed by the court by the school system itself that decides this is the approach the school system wants to take in addressing the truancy issue. There is no ability to lock a child up for doing this. It is not a crime not to go to school for the child. It is not a delinquency action. It's completely separate. It could be a SINS action, but even in a SINS case, you have no ability to lock up a child. That's not part of it. And SINS cases are not brought by DJS about education. So you're not going to move into the approach that way. The other thing I wanted to point out about why it's important to have the courts involved for certain of these cases is that the literature shows us that one of the things that the court can bring to bear is a sense of authority and a sense of ability to help provide services. For the right cases, for the cases that judge that Magistrate Stewart Jones is seeing in her court, for the cases that Ms. Timmons is seeing in her court. These are cases where the school system felt the appropriate way to reach the child and the parents was bringing them in front of the court. And that court's authority has worked positively to help the families create the changes that children need. You're absolutely right, Delegate Charkoudian. It is not right for every single case. It is not right for every single family. But for those families that the school system and the court agree are appropriate for this program, they are remarkably successful in bringing children in and helping them and their families to address the issues. I hope that helped a little in explaining it. The last thing I want to point out in the funding issue is that these programs are supported by the Administrative Office of the Courts. After a program gets established, after the legislation permits it to be established, the program essentially writes a grant application to the the Office of Problem Solving Courts. It goes through a board there that reviews it, and funding is provided. Funds come out with the annual funding cycle, and they may receive money from other places. The majority of the funds are coming out of the Administrative Office of the Courts budget.
Thank you. And Delegate Stewart, you have a question?
I do. Thank you, Madam Chair. Well, thank you, Madam Senator, for bringing this bill. Your Honor, it's great to see you as well. This is a really interesting issue, and I think really important, and it's a big problem and clearly a growing problem. And I'm actually personally, maybe I'm like just biased in favor of courts. I personally think that courts, my assumption is that they can absolutely be part of the solution, like they are in the number of other social problems we're facing. But Miss Kaplan she actually provided a perfect segue because she said my favorite word, which is literature. So I've spent basically this entire little mini hearing we've been having here trying to find literature on this. I went to Ms. Timmons, I went to y'all's website, attendanceworks.org, and I went to the research tab, and then I clicked on truancy, and then I sort of did a very cursory look at a bunch of studies. And it seems like some of the studies that y'all cite to sort of poo-poo the idea, for lack of a better term, of court programs, like as court as where the center of the locus of this activity should go. And I know that your organization supports sort of diversion generally and sort of, non-punitive approaches. So my only question is, I'm sure there is a bountiful amount of literature out there, as Ms. Kaplan said. Could you, Ms. Timmons, or you, Ms. Kaplan, or someone just share the literature with the delegation of sort of all these different settings that these kind of wraparound support services may occur, and which one has been most effective? Because clearly we are not the first county to ever confront this problem or to try to experiment with possible solutions. So that is my only question and request. If y'all could please provide us with said literature, it would make me, and I'm sure some of my colleagues, very happy.
We will. We'll also provide you some numbers of what has occurred in Maryland. We have a nice little chart, which if it's not been provided already, it will be, to give you the idea of what's happened already.
Thank you. I appreciate it.
To clarify for the record, I do not represent Attendance Works. I am an employee of the Circuit Courts of Worcester, Wycomico, Somerset, and Dorchester County.
Sorry about that. I totally whiffed on that. I just saw the graphic and I just started Googling, and before I knew, I totally given you a new job.
I appreciate it.
And Delegate Fraser Hidalgo.
Thank you. Thank you. Thank you, Madam Chair. And so I guess a couple of questions, but one of them is, I think someone mentioned that this is referred by the school system. Is that correct?
Yes.
So we're at the point now where we have 34,000 students in Montgomery County Public Schools that are truant and or have truant-like behavioral issues. And the school system is clearly, there's clearly an issue that is not being addressed. And this has taken place to some degree since the pandemic. Now we have another pandemic of truancy. And so this is another tool in the toolbox to help address truancy that only moves forward if the school system deems that everything else that they've tried hasn't worked. So this is their kind of last course of action. Is that correct?
I think that's a fair assessment, that sort of the school system has worked through some things, and this would be a next step. Again, voluntary. Parents and child can say we're not doing it, but if they agree, then there's, we can move forward with sort of what we can do, and we can set up sort of a graduated path of let's try this first, let's try this. If it's not working, and again, Magistrate Stewart Jones has been doing it for 14 years, I think she said, can, sort of give you other examples. But the idea is we're not out, we get referred, and it's because the school system evaluates these kids and decides they need something else. And this would be one way to be able to do it, to address something. We're not going to address 34,000 kids. We don't have the resources to have all 34,000 come to the court. But if we can pick up another 300 over what the state's attorney's office is doing, that would be 300 more that we're at least providing services before they unfortunately might go down a different path.
Right, and it's not mandatory. It's just the school system saying we're kind of at our wit's end here with this particular student. We're not sure where else to go. This is kind of our last shot and maybe an opportunity for the student and parents to kind of get a preview of what might be coming should they not correct their behavior.
Absolutely.
Thank you very much.
Okay, are there any other questions? Let's see. Oh, Senator King.
Yes, I just wanted to add, there is no one solution, obviously, on this. There are a lot of different programs. They'll work for some, they won't work for others, but maybe another one might. I think we all know we have to do something because this problem's getting worse instead of better. So it's not a one size fits all by any means, but I think this is a real good shot at helping some kids.
Thank you. And I just had one further question of Ms. Kaplan. Ms. Kaplan, in the jurisdictions that currently have the truancy courts, are there other programs that they have that are also addressing the truancy problem? Because here in our county, we seem to have 2 programs, and this will be a 3rd program.
I'm really not the expert on all the other services. We'll look into that and put that together for you, the other programs. And I think Ms. Timmons might know just briefly now what else is in her county as well.
Or Magistrate Stewart
Jones.
Are there other programs in Prince George's County?
There aren't formal programs. Our state's attorney's office has been trying to address this as well. Years ago, there was a program where the juvenile judge in charge went to the schools and basically had sort of like town hall meetings with those students and families that were identified by the schools. And they said that having the judge present made a lot of difference. A lot of those families were then more inclined to even come to our truancy reduction court program. So we did meet with them a few weeks ago, and that's one thing that they asked the court if they could put back in place. So it hasn't been a sustainable program like Montgomery County has through the state's attorney's office, but they've tried different things in the past.
Thank you. Okay, any other questions? I don't see any, so that would conclude our hearing on MC 13-24. And thank you so much to all of the witnesses tonight for all the 5 different hearings that we've had. Again, thank you, and I'm going to turn it over to our Madam Chair.
Thank you, Chair Crutchfield. Just a few logistics before I turn it over to Senator Kramer to close us out for tonight. We will be continuing our public bill hearings on local and bi-county bills next week on Monday, December 4th. That is going to be in person in the County Council chambers in Rockville. If anyone is interested in signing up to testify on any of those bills or to submit written testimony, that is open here, I think until, I believe the deadline is the day before the hearing, and you can go on our delegation website to find out details about that. Otherwise, this is just the first step of the process for all of these bills. All of the bills will be discussed in work sessions in local committees in the coming weeks and months, and you can find out the status of the bills and when they will be taken up on our delegation website. And with that, I will turn it over to Senator Kramer to close us out for tonight.
Thank you, Madam Chair. Just want to say good night to all, and I'll see you next week at our next bill hearing.